All right, we're going to call the meeting to order now. Everyone. So the first item on the agenda will be a vote on the draft January 9th and March 13th board minutes, which board members have received. Is there a motion to approve the minutes?
So moved.
Is there a second?
Seconded.
So does anyone have any discussion or edits or corrections they want to make? No? Okay. Is there a motion to approve?
So moved.
All in favor? Okay, thank you very much. The minutes are approved. So before we get into the main agenda items of today, I think it appropriate for me to address what we perceive to be certain misconceptions with respect to the roles and responsibilities of the Board of Correction. I will first address the Board of Correction as an institution. Why does it exist, and what role does it serve? I will address, in addition, this particular board and how we view our mission. First and foremost, I want to remind everyone that the Board of Correction is an independent oversight agency. Our role is to regulate, monitor, and inspect the city's jails in support of safer, fairer, smaller, and more humane jails. The board monitors conditions of confinement in compliance with our minimum standards, documents systemic issues of a problematic nature, and informs policy decisions and policy improvement with respect to the city's jails. The board does not have the power to mandate or to manage the operations and services within jails. That is the sole responsibility of the Department of Correction and the Correctional Health. Incarceration is part of the work of government today, and we understand and appreciate the fact that when government uses its power to deprive people of liberty and to isolate them from their communities, incarceration must also include ongoing transparency and accountability measures. That is why the Board of Correction was created in the first instance. In the early 1950s, Mayor Wagner, then DOC Commissioner Anna Cross, and a task force of other city leaders, including future Mayor A. Beam, created the Board of Correction to monitor the New York City jail system on behalf of the public, to provide planning assistance to the department, and to solicit and consider diverse viewpoints regarding the issues facing the city's jails. Since its early public reports, the board has had full access to DOC records and facilities and focused on data-driven oversight and data-informed policy decisions. In its early years, the board pushed for critical, long-standing reforms, such as ending the use of bread and water diets as punishment, requiring mattresses and running water in segregation cells, developing a methadone treatment program, creating the Suicide Prevention Aid Initiative, instituting prenatal services at the women's jails, and adding telephones to each housing area. In 1975, New York City voters revised the city charter to create an independent Board of Correction with a staff and budget, subpoena power, and the mandate to write local regulations to be known as minimum standards. Board accomplishments in the years after the 1975 charter revision included the creation of a formal grievance system for people in custody, and the development of the first jail mental health standards in the United States. Over the years, Board of Correction membership has consisted of leaders from various sectors of New York City life, including physicians, lawyers, government and corrections officials, judges, district attorneys, clergy, journalists, academics, and juvenile justice practitioners, among others. We know that the DOC and Corrective Health take seriously their responsibilities for safe, fair, and humane care in custody that minimizes the adverse impacts of incarceration on inmates specifically and on the communities generally. Civilian oversight, like that of the Board of Correction, is a tool to facilitate the transparency and accountability needed to support and evaluate these core responsibilities. Indeed, more cities and states, as part of their justice reforms, are creating bodies similar to the one in New York City that New York City's had for over 60 years. Unlike many of our peer agencies, the board has regulatory authority, the power to write, amend, and grant variances from the minimum standards. In 1978, the board adopted a set of 16 minimum standards to provide what is considered to be the basic elements necessary to ensure the safe and humane incarceration of people in custody. The minimum standards, which comprise Chapter 1 of our rules, reflect the general principle of least restrictive confinement and have been refined by multiple court orders mandating policies relating to non-discriminatory treatment, classification, lockout time, recreation, religious access, access to the courts, visitation, telephone calls, correspondence, packages, publications, and media access. Our standards also reflect state and federal constitutional rights. Standards from other jurisdictions, including the New York State Commission on Correction, and best practices in correctional facilities around the United States and throughout the world. And remember, they are called minimum standards for a reason. Compliance is required with respect to our minimum standards. Compliance is not an option. The minimum standards have governed critical areas of life inside the New York City jails for almost 40 years. Within these parameters, the department has wide latitude to implement policy in ways that it believes to be fair, safe, and efficient. For example, our minimum standard on recreation requires the department to provide daily 1 hour of outdoor recreation. It does not, however, prescribe anything further as to how the department should carry out this requirement. Moreover, this and other Chapter 1 standards expressly permit the DOC to impose restrictions on individual access to mandated services based upon safety and security reasons. If the department cannot comply with a minimum standard, it can apply for variance. The board always has and will continue to work collaboratively with the department in responding to variance requests. As evidence of this, in 2016 and 2017, the board approved 32 of the department's 34 variance requests. This collaborative approach also holds true in the department's violence prevention and safety efforts. Let me be clear. The health and safety of people in custody and people who work in the jails is a primary concern of the board, as it is with the department. We, as well as the department, make all of our decisions with this concern at the forefront. Any suggestion, as was made at last month's board meeting, that the board, as an institution, engages in confirmation bias is simply misguided and wrong. The city charter mandates that the board perform independent oversight of the city's jails. Each of us takes this responsibility very seriously and is committed to utilizing our best, unbiased, and considered judgment in carrying out our legal mandate. The constituencies that we serve, the mayor, the city council, all those who work in the city jails, and all those who are incarcerated in them, and the general public included, deserve nothing less from us. This board's independent oversight should not be mistaken for confirmation bias. To the contrary, all the rules we enact, all the variances that we approve, and the conditions upon which we grant them, and all the reports that we render are the product of data-driven analysis, quantitative observations, and significant input from the DOC, other city agencies, advocates, and experts. In 2015, the board, with the support of the mayor and other elected officials, the Department of Correctional Health, and many advocacy groups, amended the minimum standards to create limits on the use of punitive segregation. The 2015 punitive segregation amendments established safeguards on who could be placed in segregation and for how long, and for what reasons. Before the amendments, close to 20% of adolescents in custody were in 23-hour lock-in, and the number of people in isolation had grown 225% in the previous 10 years. New York City had one of the highest rates of punitive segregation in the nation and was overusing punitive segregation as a behavioral management tool in the jails. When the board, in collaboration with the DOC, created limits on punitive seg, it based its decisions on numerous evidence-based studies showing that misuse and overuse segregation is not an effective behavioral management tool and does not deter violence. A vast majority of correctional experts agree that isolation of an individual for extended periods of time results in a distinct set of emotional, cognitive, social, and physical pathologies. Segregation is particularly damaging to young people. people with serious mental illness, and the physically disabled. The city's punitive segregation units were also places with high rates of assaults on staff, suicide, self-harm, and splashings. New York City leads the country in reducing its reliance on punitive segregation. The DOC, in collaboration with the board, eliminated segregation for adolescents and young adults. We are the only jurisdiction in the country that has eliminated punitive segregation for 18 to 21-year-olds. As the approach to law enforcement evolves around the country, correctional systems are joining New York City and reforming their use of punitive segregation. This includes jails and prisons in Cook County, Texas, Washington State, Colorado, the Federal Bureau of Prisons, and many more. Today, the segregation population in New York City jails is 1/5 of what it was during the period before, during the year before 2015 reforms were put in place, and 10% of what it was in 2012 at the peak of the use of punitive segregation. Significant, significant reductions. As the department planned to limit the use of punitive segregation in 2014 and 2015, it developed alternative responses to violence and misconduct. At that time, the department petitioned the board to enact a rule to permit the use of enhanced supervision housing, or ESH, as an alternative to the long-term use of punitive segregation. The board ultimately wrote ESH into the minimum standards. The department created other alternative housing for adolescents and young adults, such as young adult ESH, secure, true, and second chance. And the board approved and renewed multiple variants, 19 variances in just the past 2 years, enabling the DOC to create more housing options for promoting safety and holding accountable those who commit violence and other misconduct in the city's jails. There are currently 47 different restrictive housing units in the city jail, spread across 16 types of restrictive housing. There are just over 450 people housed in these units. Inmates in these units are subject to restrictions on out-of-cell time, commissary, recreation, packages, mail, law library, showers, television programming, commingling, visits, and personal property. Recently, the city administration and the city council have invested in the Board of Correction as never before, adding much needed resources to expand and enrich our oversight efforts. In recognition, this new investment was all in recognition of the critical role that we play in providing objective and trusted reporting, accountability, and regulation. And in closing, just let me say this vision this was the vision that the founders of our Board of Correction had 60 years ago, and that's still our mandate today. I know that I speak on behalf of the full board here when I say the board looks forward to our continued collaboration with all concerned, all of our constituencies. Thanks so much. Now we'll get to the rest of the agenda. Right back.
We're going to move on to the sexual abuse.
Yeah, the sexual abuse
standards.
Yeah, that's Martha.
Yeah. So I last reported on the implementation of these standards to the board and to the public in September 2017. And moving forward, BOC staff will continue to provide updates at these public meetings every 6 months on these provisions and on the provisions that DOC, Correctional Health, and the board review together in quarterly meetings in between these public meetings. I'll focus primarily today on the issue of investigations, since there are a great number of challenges to be addressed by DOC there, and because their first public self-assessment report, as required by Standard 540, focuses on this issue. Before getting to investigations, I'll just update you on the DOC's screening for risk of sexual victimization and its use, which can be found in Standards 517 and 518. At the September BOC meeting, the staff report that I gave noted that DOC was not meeting the standards in this area because of obstacles to tracking and using information gleaned from the intake screening. BOC staff noted that the paper-based system presented major challenges. As a result of the board's unanimous resolution for corrective action, DOC made much progress. The board's resolution passed in October 2017, And by February 1st this year, DOC had implemented an electronic screening process to assess and reassess people for risk of victimization and abusiveness. This is very important progress, and BOC will monitor for its impact moving forward. DOC also began tracking housing placements and housing placement reasons for all new admissions of transgender people in custody, as required, and that began in November. They've since added all housing movements of transgender people, and as of February 1st, they are now consistently reporting to the board about the placement and movement of all transgender people in custody. They are also submitting all of the THU applications. We're working with DOC to further improve the use of this data. Since DOC began reporting this information, and since the board study of the THU was released, there seems to be an uptick in approved applications to the THU. Since November 1st, sorry, I'm gonna scratch that. The city's recent announcement to house in accordance with gender identity in the city's jails within 6 months will further DOC's compliance with board standards in this area. Before the 6 months arrives, BOC and DOC need to arrive at an agreement on how to improve these case-by-case analyses that are required by the standards in the interim in order to prevent abuse and victimization. I'll talk a little bit about compliance with some important reporting requirements. The board standard 540 requires DOC to submit incident-level data to the BOC and to issue a public self-assessment every 6 months. The data reports that DOC has submitted to us are still missing a significant number of data points that are critical for both DOC and BOC to know, including the times of incidents, the demographics of victims, such as race, disability status, and LGBTI identity, whether the alleged perpetrator and victim were separated during the investigation, and if previous allegations of abuse or harassment were lodged against the alleged perpetrator. The board is awaiting response from DOC about these critical data deficiencies. DOC is still out of compliance in their submission of the closing investigation memos, but is aware that they need to quickly institute a system to get those to us in real time. We've received 66 closing memos, 7 from 2015, 55 from 2016, and 4 from 2017. We intend to audit the closing memos before the next report in 6 months. And last evening, in good news, DOC also submitted an additional batch of memos. DOC is also behind in their completion of sexual abuse incident reviews, and thus in their submission of those reports to us. These reviews are obviously extremely important as they give staff an opportunity to review the case after the investigation has been closed, look at related lessons, and then make recommendations about any steps at the facility level that could be taken to reduce future risks for others. The PCMs, the PREA coordinator managers at the facilities lead these, and the PCMs are still below the head count that DOC wants to get to, and they've also been redeployed to conduct PREA training for DOC each week as a result of the end of DOC's contract with the Moss Group. And obviously, conducting training every week is a significant time burden, and that takes away from their ability to conduct the sexual abuse incident reviews. And that's led to a delay in completing these. DOC anticipates getting up to date on the 9 overdue reviews next month. DOC also successfully started its quarterly reporting to the board on any placement of a person into involuntary protective custody due to risk of sexual victimization. Protective custody standards can be found in 519 and 529. DOC has submitted 2 reports as required to date, and according to those reports, involuntary protective custody is used in these cases extremely rarely, and in fact only once in the reports that we've seen, and that was for less than 48 hours. As of mid-January, there were close to 400 people on the voluntary protective custody list and about 10 people on the involuntary protective custody list. According to DOC, none of the people on the involuntary protective custody list are on it because of risk of sexual victimization. If that does occur, BOC is to be notified. DOC owes us some data on the number of people placed in voluntary protective custody due to the risk of sexual victimization. Because of the high number of people filing complaints about their safety and about their housing classification with the board, and due to recent incidents of violence in protective custody, BOC also intends to pursue a larger investigation into the practices associated with transfer into and out of protective custody. DOC recently published one of the 2 required public reports over the past year. This report was published on March 14th, and the report shares a lot of concerning data which forms the backdrop for the implementation of all of these standards. Without prompt, thorough, and objective investigations, without meaningful investigations, efforts at prevention and accountability will fall short. From the 540 report, we know that the total number of sexual abuse and sexual harassment complaints increased by 40% from 2016 to 2017, or from 823 to 1,151 complaints. We also know the rates of allegations of sexual victimization in New York City jails increased in all categories. In New York City, the rate of reported allegations of sexual victimization was 19.2 per 1,000 inmates in 2017. As a comparison point, in New York State prisons, the rate was 10.5 per 1,000 inmates in 2015. Rates of victimization in New York City have been higher than national comparisons since at least 2011, when the Bureau of Justice Statistics released their nationwide data. The 540 report shows that investigations are not being completed within 90 days as required. Almost all 2016 and 17 investigations of sexual abuse and harassment are still open. Of the 1,974 complaints from the past 2 years, 94% of the investigations into those are pending. Rates of substantiation in New York City remain below national averages, as they were before these standards took effect. So today, we're going to ask DOC to speak to the barriers to timely completion of investigations, the reasons for this backlog, and their plan for corrective action.
Good morning. Thank you. My name is Serena Townsend. I'm the Acting Deputy Commissioner of Investigation and Trials as of February of 2018. I joined the department in September of 2016 as the Deputy General Counsel of the Trials Division, and now with the Trials and Investigations Unit combined, I oversee both. Prior to that, I was a Deputy Bureau Chief at the Kings County District Attorney's Office, where I was for 10 years. I prosecuted thousands of cases, including over 50 sexually based felonies, including rape, predatory sexual assault, and sexual abuse. My comments this morning will concentrate on the Investigation Division's compliance with BOC's minimum standards and our plans, and how we've started to implement those plans to address the pending matters within our division. Pursuant to the board's minimum standards, our department's investigation unit has an obligation to promptly, thoroughly, and objectively conduct investigations into alleged sexual abuse and sexual harassment. The department has specially trained PREA-certified investigators conducting PREA investigations within 72 hours of referral to our unit. We obtain clearance from DOI. We conduct investigations, which includes interviewing and assessing the credibility of the alleged victim and witnesses, reviewing video, assessing the alleged scene of occurrence, preserving and analyzing physical evidence, and documenting all of our investigative steps as we proceed. Where the allegation is that an inmate sexually harassed or abused another inmate, we prepare a separation order to separate them. Where the allegation is that a staff member sexually harassed or abused an inmate, at the very least, we separate them. And on particularly egregious allegations, we also modify and/or suspend the staff member. The department takes very seriously every allegation, and in an unbiased fashion, we follow the evidence to the appropriate conclusion. For the 2016 and 2017 time period, the department's total PREA caseload was 1,696 cases. This includes all sexually based allegations, from an incident of just one inappropriate comment made, all the way through an incident of physical sexual assault. Every single one of these 1,696 cases has been investigated by the department's PREA certified investigators. within 72 hours. The main reason that the cases are pending and are open and are being reported as such, mainly they fall into two categories. One, the closing memorandum has not been drafted or completed, meaning it's an administrative issue that we're facing. Or two, the case is in need of a final review by a supervisor to determine whether the investigation requires any additional steps or follow-up before closure. The vast majority of our open cases actually fall into that first category of an administrative barrier. We have a targeted strategy that the department devised in March of 2018 and have begun to implement in order to close these pending cases that we have already investigated. In order to address this administrative issue, the department has reformulated our closing memorandum. Our first draft of that reformulation was March 2nd of 2018, and after a few rounds of edits, we began using the memo officially April 16th of 2018. This expedited closure memorandum is a shorter version of the closing memorandum that was used in previous practice, and it allows the investigators to close out their cases on an administrative basis more swiftly. It's more user-friendly, less cumbersome, and shorter. But notably, this expedited closing report does not compromise the integrity of our investigation itself. It's purely an administrative tool that allows the investigator, after a thorough investigation, to wrap up the case. And this form will only be used on cases that we determine to be unfounded or unsubstantiated. The department's plan to address the closure of cases is to do so strategically by category. So in 2015, 14 inmates were responsible for 69 of our PREA allegations, which represented at that time 22% of our 2015 caseload. In 2016, 17 inmates were responsible for 181 of our allegations, representing, again, 22% of our caseload. In 2017, 16 inmates were responsible for 269 allegations, representing 23% of our caseload. And so far, in 2018, 18 inmates are responsible for 123 of our allegations, which represents 34% of our 2018 caseload. So all told, taking all of those numbers and years together, 25% of our caseload, 542 cases, are cases made by the same 53 inmates. We plan to close any cases of those 542 that we've unsubstantiated first. Now, the department has substantiated cases from some of those 53 inmates. We have substantiated some, and I raise that in order to explain and so that I don't misrepresent what we're doing here. We take every allegation seriously. It doesn't matter if it's your first allegation or your 30th. We investigate each one thoroughly before we make a decision on the evidence as to whether that allegation will or will not be substantiated. However, the vast majority of those 542 will be closed as unsubstantiated pursuant to our investigation. We plan to close those out first. Lastly, the department is currently conducting interviews in order to staff more fully the investigation division with additional investigators and supervisors. In November of 2016, the department had 14 PREA investigators. We are now up to 19. It is a start. Hopefully by now I've made clear that the open caseload is not due to a lack of investigation or severely delayed investigations, rather a lack of time for department investigators who are out doing those investigations in all of the department's jails. It's difficult for them because they're conducting those investigations to complete their paperwork. That is the direct cause of the so-called backlog. Adding staff will give the investigators time at the jails to investigate and time back at headquarters to complete administrative tasks and receive final approval. In the meanwhile, while the department awaits the hiring of these new investigators, we do have a temporary solution. Because our investigation unit has recently combined with our trials unit, the department has leveraged that relationship and pulled one of the trials supervisors to assist in this administrative task of closing these cases. She'll be starting on this task Monday, April 23rd, and she has completed her PREA certification training this week. In conclusion, whereas the department is working to achieve compliance with the BOC standards in this very important, essential task of investigating allegations of sexual harassment and abuse, we acknowledge the need to improve on our ability to finalize these findings and close them out. We anticipate that with this targeted strategy, the department will soon be in a position to better manage this administrative side of our investigations. Thank you for your time and your careful consideration.
Any questions or comments here?
Thank you.
Could you talk about the other issues? I mean, you talked about the fact that there are people who have made substantiated complaints and sort of blame the problem on them, but that only describes. There's another 75% of the cases. As I understand it, the strategy of the department and the board's encouragement in terms of our rule is to create a situation where people who allege that they were sexually assaulted or abused have the opportunity to make a complaint, which will be heard and corrected. And your corrective process is through investigation and sanction, if there's a reason for it. But if you don't complete these things, if 94% are not completed over 2 years, what kind of strategy for change in the department's for protecting people from sexual abuse? Why don't you, if you could engage that question right now, because
Sure.
but before you'd really just blame these people who send in too many confidential allegations.
Well, to clarify, I'm not blaming anybody. I'm just explaining that 25% of our open cases are within that realm. But to address your concern and your question, we agree that in order to pursue discipline in the appropriate places, we do have to push these cases forward, and they cannot stay open. And so our targeted strategy is to not just investigate thoroughly and swiftly, but to now administratively push forward the cases where we are substantiating the claims and discipline appropriately. In fact, we are on trial right now with one such person. So we do take that very seriously, and our strategy now is to be able to move these cases forward where they need to be moved. And we're going to be doing that through our targeted strategy and through our hiring.
Understand why that hasn't happened over the past 2 years. I mean, if you have, why was that not always the strategy of the division?
Ideally, that is always the strategy. We unfortunately need some more staff in order to make that happen, so that we have the ability to take these cases that the investigators are investigating and close them out. The investigators are being used at this time to investigate, and so they are out interviewing witnesses, assessing the scene, reviewing evidence and video, and that is where their attention is. Their attention is to address the complaints as soon and as thoroughly as possible. And so when making a decision about whether to address an issue and interview a complainant versus file paperwork, their attention is on the complaint and on the complainant. So we are hoping with this strategy to be able to address both issues and move the cases forward.
What is the staffing pattern, and do you believe that the staffing pattern that you have for investigation and review, then the necessary follow-up is what it should be?
I believe that currently, the way we are staffed, we are able to conduct these investigations in a thorough manner, and we are not having an issue with the integrity of the investigation, but that we need more staff in order to be able to close the cases more quickly. So ideally, we would have at least another 15 investigators in order to be able to move the cases more quickly.
What is the caseload?
So our current caseload is approximately 2,200.
The caseload per worker?
Oh, per actual investigator?
Yes.
We have 19, I can't do the math right now. We have 19 investigators for a 2,200 caseload. And we have supervisors as well, but the investigators themselves are the ones who conduct.
2,200 cases that are open, or 2,200 cases that were investigated just waiting administrative closure?
We have 2,200 cases that fall into the latter category. Essentially, they're open with us, but they've been investigated in those first 72 hours and are awaiting final closure. Yes.
Hi, good morning.
Good morning.
And you know, your career, your family should be proud of you. You've had a
Thank you.
But just getting back to the caseload, right? You're up 40% from 16 to 17. Forgetting about the administrative, forgetting about the caseload.
That's right.
This is a significant problem. Also, what do we think about that? Why is that occurring? What is happening? Is there a problem of culture? Is there a problem? And Commissioner, if you have an opinion on this, I'd be interested in knowing too.
Well, initially, I think we believe that a lot of that has to do with more information that is being brought to the inmates' attention, that they are more capable and more able at this time to lodge complaints than they were before. I think that's one of the main driving factors here.
And just back to, so of the 2,200 that were investigated and is just awaiting administrative closure, how many of those cases have been substantiated?
I don't have that figure on me right now, but the vast majority were unsubstantiated.
Unsubstantiated. For the ones that were substantiated, has any action been taken, or the action is taken after the administrative filing of the paperwork and closure? What happens to the cases that were substantiated?
The cases that are substantiated make its way towards the trials unit for the appropriate discipline. And so, like I said, even as we speak, we have a case that's pending in front of oath that we are prosecuting.
Do you know how many were substantiated, if not that many?
Off the top of my head, I don't have that figure, but I can get that to you.
Okay.
You don't have to wait for that closure to separate individuals where allegations have been made. Right?
Absolutely not. We do not have to wait for that closure.
Can I just ask you a quick question? I'm just trying to understand, see if I follow what you just said. So, of the 2,200 open cases, when you said, I think you said a majority of those were unsubstantiated, is that a conclusion, or does that mean you haven't finished the analysis is that a final conclusion, or is that a kind of an interim conclusion?
That is essentially a final conclusion, and we just need to close those cases out administratively.
So then a majority of the claims of sexual harassment or sexual impropriety generally are unsubstantiated.
I can't speak to generally, because we take each case very seriously on a case-by-case basis.
But I'm saying of the 2,200.
Of the 2,200,
more than half are going to be
majority, yes,
yeah.
the majority
Okay.
are unsubstantiated. That is correct.
Yep.
The 540 report noted that there were 3 substantiations in 2016 and 1 in 2017.
Does that mean there are no more than one from 2017 that you've substantiated? I know the report says 1.
Yes.
But you say there are others. So is there more than 1 in 2017?
I would have to look at that again just to make sure I have an appropriate current figure for you.
But you don't know, is it more than 1?
From 2017? Well, the report is accurate, but if we have some that have come up since then, since the report was filed, then it may affect the numbers. But that report at that time that was filed, I believe you said March 14th, is accurate as to the 1.
That report was due in August. Why was it filed in March?
That I can't speak to that at this time. I apologize.
Can you speak to that?
Is there a plan to complete, like, what are your targets to get some of the old open cases closed? Do you think it's a period of 6 months where you close 500? Is it?
That's a fair question. I think some of that has to do with how many staff members we end up having approval of hiring and how many we're able to get on board and how quickly we can get them on board. but we are trying to make as aggressive a goal as possible.
Yeah, sure. Judge Allen.
Yes, I realize you substantiated very few cases.
Correct.
But in the very few that you substantiated, are those prioritized for closing and to get to trial?
Yes.
And what tends to be the time period between the closing of the investigation or the substantiation and getting that case to trial?
There's a lot of barriers actually to get a case to trial that are outside of our control. So once a case is closed as substantiated, it comes down to the trials unit, at which point the trials attorney drafts charges, serves discovery, has to get a pre-conference trial date on the oath calendar. We are allotted just Wednesdays to be appearing at oath, and 12 cases each Wednesday. So if you take that number into consideration, you could probably understand that sometimes it takes time to get onto that calendar. But once we get onto that calendar, then we ask the judge for a trial date, at which point the judge gives us a trial date, and then we can try the case. That is if there is no negotiation pre-trial. So I don't have an exact figure as to how long it takes because each case is different. A lot of it also depends on the respondent's counsel, whether they're satisfied with the amount of discovery, whether they're ready to proceed, and how they want to resolve the case. But we obviously look at these cases very seriously in the trials unit and take those cases as soon as possible.
So you're aware, as I'm a former sexual abuse prosecutor as well, and we know that it's very important. Time is of the essence,
Absolutely.
Right? In particular because our victims, alleged victims, complainants, are incarcerated and they're only at Rikers for a certain period of time. The risk of losing your witnesses' memories phasing, losing the evidence is much greater with your cases. Why is it that these cases, especially where they're substantiated, can't be prioritized? I mean, the alternative is that you're actually potentially leaving perpetrators to be in the jails and continue to perpetrate sexual abuse.
A couple of responses to that. I acknowledge, I mean, you and I have the same background, so I think we both understand the importance of getting cases to trial, if they are to go to trial, as soon as possible. We do prioritize these cases. These kinds of cases that we have here are very serious cases. We usually don't negotiate a disposition on these cases. We usually do push these cases to trial. The trial track does take some time because of outside entities, but these cases are prioritized, and we try to seek to go to trial faster in these types of cases. And as for having the alleged perpetrator, if we substantiate a case, we do modify that alleged perpetrator so that they do not have inmate contact for the pendency of this investigation and prosecution.
So one last question then, is there a change in protocol? I know when we were investigating PREA, the rulemaking, and I was on that committee, and we had a lot of different meetings. At that time, it sounds like it was before you arrived, we were told that there was a much greater emphasis to try to reach a resolution and have officers resign versus forcing a termination by holding them accountable at a trial. You're saying now that you don't negotiate settlements, that you rather go to trial. So is that a change then? Because that sounds quite a bit different.
What we try to do is we try to negotiate a plea agreement wherein they will agree to resign. However, there are situations, many situations, where the respondent doesn't want to resign. And when faced with that situation, our only alternative is to take that case to trial and seek termination.
And I'm sorry, that wasn't my last question.
That's
Maybe
okay.
this is more of a statement. Having done the work we've both done, we know that the police department is held to a very high standard to investigate these sex crimes quickly, close out their paperwork, refer it for an arrest or whatever is going to be done. Shouldn't the Department of Correction be held to the same standard as the police in terms of investigation and closing out these cases?
I think anybody who's involved in these kinds of cases should be held to a very high standard.
I just wanted to, I was just going to say, you have a hard job, but not, I mean, you have a job, and I appreciate your coming. I mean, your change in, your leadership of this combined division right now, and I wish you best, but it's of great concern to the board. I mean, we didn't, you know, we were asked to make PREA rules. You know, PREA sort of existed already, but we felt that we think it's very important, and we believe that the department believes it's very important. It's not been demonstrated in the past 2 years. It's very embarrassing and dangerous to have the current situation going on. So I hope you will get the staff that you need and be able to report back to us in a timely manner, not 8 months late, about what you're doing.
Thank you very much.
On that note, I think the board would want to work with the department to try to finalize a correction plan by June. So we would all try to get together and put something together that would prove to be effective as a corrective measure by June. So the two groups.
I would just like to add one comment. What the Deputy Commissioner has referred to regarding the process with oath and the PREA investigations, it doesn't just apply to PREA, it applies to all cases. So when you think about all the other work of the department and the fact that we appear 1 day a week before the oath judge to conference certain cases, it's all together, which also further informs what the department's challenges are.
So what's the timing on adding the additional staff? Sorry, Stanley, you can. I just want, since you said it's a combined effort of all the different prosecutions. You sound like you have a staffing problem, or at least a resource problem.
We're working to address that and have a more robust staff.
So what I would suggest is that within that corrective action plan that be included in that an assessment
Yes.
of the staffing patterns, the caseloads, and what can and should be done.
Yes, ma'am.
Thank you.
Yeah.
And just, could you talk a little bit about what you said, that, you know, improve communication so people know how to report? That's why we're getting more cases. What have we done to communicate to visitors about how they could report sexual abuse or?
So I think one of our main priorities is to inform people of how to make these kinds of complaints, and we've had signage go up with information about how to report, which I think is the main way that we've been able to inform the inmates.
At the visit house and then visit, like how are we communicating to the visitors about how to make a complaint? Is it signage in the visit house? Is it signage on the visits in each facility?
It's signage in several different locations. Yeah, and we think it is working because we are getting more. Getting more.
Are we tracking how those complaints are coming in so we know which strategy is working, whether it's?
Okay.
We do know where the complaints are coming from. I don't have numbers for you today, though.
I'd like to know that if we could follow up.
Sure.
Just one follow-up on the staffing question. We are awaiting the executive budget at the end of the month, but what we also have referenced in the past is some of our challenges with retaining some of the investigators that we have brought on. And we continue to recruit, we continue to try to bring on the best qualified candidates, but sometimes it's very difficult to fill those positions and retain the investigators.
Thank you.
Thank you very much.
So a couple of comments on the next topic is the transgender housing unit. Earlier this week, the department made two major announcements that also reflect the board's regulations and recommendations for ensuring safety of transgender people in custody. First, the department announced that it would house people in custody consistent with their gender identities. The board already requires an individualized housing determination that accounts for a transgendered person's own views with respect to his or her safety, and this announcement aligns with this requirement and goes even further in the right direction. Once fully implemented, the department's policy will be in compliance with the board's minimum standards on this matter. The department's announcement is a much welcome change and will greatly contribute to the safety and the dignity of people in custody. Additionally, the department announced this week that it intends to keep open the THU unit. That people in custody and their advocates have petitioned for this position for some time, and over the years, various board members and staff had cited the importance of the THU as a housing option for transgender people. But in view of these recent developments, very recent developments and very important developments, the department has noted that it is not currently prepared to discuss in detail any of the implementation details of the new THU unit. So we would give the department certainly adequate time to determine how they plan to implement this going forward. The board welcomes the department's decision to continue to operate the THU. As discussed at last month's public meeting, the board believes there's a great potential in the THU as a violence prevention tool. However, there's significant work the department must do to improve management and operations of this unit. The board's THU assessment includes findings and recommendations meant to inform the unit's operations and future plans. At last month's meeting, the board presented these findings and recommendations and requested a response from the department. The board has sent the department the final report 1 month prior to publication in order to provide the department time to respond. The board has not yet received a response, despite the department's statement at the last public meeting that it had concerns with the report. In light of the recent announcement that the THU will remain open, the board understands the department is now working with government partners on plans to improve the THU. The board has requested that the department respond in writing to the recommendations in the report within the next 3 months. We're now open for questions. Anyone has anything they want to, statement they want to make there?
Yeah.
And I would want to just also ask the department if the 3-month timeline is something that you think you would be able to accept or meet.
Yes.
Thank you.
How about 2 weeks, Jeff? I mean,
I actually don't know. I'm actually just consulting to try to get more detail, but is the person who happens to be standing up here authorized in the 3 month? Yes.
Okay.
okay.
Is that an unequivocal answer? We accept it? Yeah, Dr. Cohen.
I don't understand why the department, I don't understand why the department didn't respond before, didn't respond when questions were asked at the meeting, didn't respond when the board sent them an email a few weeks ago asking these questions again. Nothing's going to change in 3 months, and this is very important because people are injured by the lack of a reasonable process to access the THU. This is not invented as a way to just create another bureaucratic project for the department. This was created because it's unsafe, particularly for these women in general population, and they should not be placed in close confinement as the department used to do before, after it closed down the THU a number of years before it reopened it. So it's a time-sensitive issue, and it's not funny to wait a lot more time when there are real issues here. So I'm disappointed that the department has not responded to the board's concerns on this, although I credit the department and the City of New York and all the people who worked very hard to achieve what will happen, I guess, right now in terms of placing people not based upon their biology, but by their gender preference in housing. That's a tremendous accomplishment by the Department of Correction and by the City of New York when it happens. I would urge that you start doing it now, that you don't wait 6 months to do it. One, because your policies are not going to be based upon anything, because there's no experience in this. You're going to have to be making it up as it goes along. So it would be better for you to put some people in, because no one's done this kind of project before. So this is all to your credit, Jeff. But it gives you a chance to, but I'm saying that rather than wait a period of time before you implement it, you should begin to implement it sooner. There are 2 women right now who are, one who has been requesting for months access to living in Rosie's, to living in Rose M. Singer Center, because she's a woman, she's a transgender woman, and she's asked for to go into this, to be transferred there. She has grieved your decision not to transfer her there. She's gotten no response to her grievances. She feels, based upon her experience at Rikers Island, that she is at great risk, and I have no reason to think that she's not. I mean, I think there's a reason to have the protection either offered by the THU or by a women's facility, for her. There's another woman who is currently being housed in the West facility, who has claims of several severe sexual abuse within the facilities, and she should be placed in Rose M. Singer also. She should be placed in a safe place, but not be condemned to close custody, which is what she's going to have essentially in West facility, because that's the way you structure that place. So I just urge you to recognize that this is more than time sensitive. This is going on right now, and the safety of transgender women is at issue. And I urge you to look carefully at these two and any other cases that you have that I'm not aware of, and maybe you can explain to me why these two people are not in Rose M. Singer right now.
I don't have specific knowledge about these two individuals, but I do hear what you're saying, and the department hears what you are saying about what it is that we should be able to do in the next 6 months, and if there are ways to consider how it is that we can implement in phases or whatever it is that might be possible. But everything's on the table for consideration right now because we take this very seriously. We're very proud of this announcement, and we're looking forward to working with many of the constituents and stakeholders involved in this process. And so we are committed to doing this and doing it right. If you go through and you implement things too quickly, the concern is that it will not be done in an appropriate way. But we're committed to looking at this and taking a very close look at this and trying to see what it is that we can do sooner rather than later.
Fair point. We certainly think expeditious implementation is important, but also understand with the new developments, it's going to take you some time to get it going and get it going right. You need to, I think, balance those two efforts, but fair point. Martha?
We'll move on. So the next item on the agenda is a follow-up to a discussion that we started at the January public meeting. In January, board staff published a report on lockdowns in the city's jails, and this week we published 2 additional reports on this topic, one that provides a facility-based analysis of the 2017 lockdowns, and a second that is an audit of the department's forms meant to document duration of lockdown, services impacted, and the reasons for lockdowns. Department policy permits staff to lock down housing areas and facilities to investigate violence, to avoid violence, to conduct searches or restore order. And during a lockdown, people in custody must be in their cell and movement and services and programming cease. Lockdowns obviously hinder DOC's and Correctional Health Services' ability to meet all of the minimum standards. And as a security response that impacts a large number of people and services, lockdowns also contribute to perceptions of unfair treatment, excessive punishment, frustrations, and tensions in the facilities. While the city saw a 32% decrease in the city jail population since 2008, there was simultaneously an 88% increase in the number of lockdowns in the city's jails. There were close to 2,400 lockdowns in 2017, which was a 32% increase or jump from the prior year. So we presented these findings in January, provided the department the last few months to review and to sort of in advance of having this public discussion, and now we welcome the department's responses and thoughts on these issues.
Thank you, Board. So I'll have the Chief come up and talk a little bit more about kind of the security measures specifically, but just in direct response, we appreciate the Board's kind of looking at the lockouts and lockdowns, we do want to emphasize that a lot of the focus of these reports seems to be in the larger aggregate, where we have, as a department, worked pretty diligently to try and change some of the specifics of our lockdown policy, particularly as we move towards an ICS system, the incident command system, that also predicated on locking down specific housing units as opposed to full facilities, changing that practice overall. So as we announce these ideas that while the population is going down and we have had an increase in lockdowns, it doesn't dig deeper into the change in that population, the change in the practices that we've made within the department, and we would encourage kind of in further conversation to kind of take a look at that. Insofar as there are dramatic increases by percentage, it also seems to be reflecting some changes in housing areas over a 10-year period that don't reflect necessarily some of the changes in the housing, the facilities themselves. For example, in very small examples, but just NIC and West Facility during that time, they were both closed and reopened. To show that there is an increase is also to say that we reopened a facility and changed the population which was in that facility. Similarly, as we take a look at kind of OBCC and increases there, it does not reflect necessarily the population. There are going to be facilities that actually are overrepresented in terms of lockdowns as a security measure because of the population in there. OBCC, as many of the people on the board know, houses our ESH, and with the ESH being an area specifically focused on those that have a higher concentration of problematic or violent individuals, then there is at least some correlation there that we need to drive into and talk about in terms of recommendations. As the chief will speak to, I think we have made some changes to how we practice lockdowns, but we do appreciate the board reporting out on them, and particularly in digging through some of the more manual things. I think one of the things that we will want to talk to with the board is on kind of the automation of how to report, because while there are opportunities to speak to lockdowns as a general number, getting into the specifics are something that is important, but also hard to do right now in terms of a very immediate way. The board spent time going through documents to kind of capture this information, particularly in terms of reasons. There are multiple reasons. As people report, some of the requirements on our end is just to report the one. So we won't talk about that in the future.
Good morning. So when we start to talk about the lockdowns, one of the things that we've done differently is that we are trying to get as many services in faster. In the matter of ESH, anytime that there's a lockdown in the area, we are now allowing programming staff to immediately come in after the housing area is locked down and that it's deemed safe. We also realize that the programming services are important, and that we're trying to, as safely and as quickly as possibly, resume all normal activities when there are lockdowns. We're also looking for technical solutions that we should hopefully have taken care of in the next several months, so that it could be automated and it could query, because as the board went through the lockdowns, it's a very tedious process, whereas it's called in to COD, and there are sometimes discrepancies between that and the MFMR. So it's a manual task that has to be done. So we are working on that, and we're also monitoring closely the lockdown reports to ensure that they're completed, and there are lockdown reports submitted for each and every lockdown.
Can I add one thing that the chief said? And I won't speak for H&H, but we've also been working closer in collaboration with them in terms of kind of making sure that any scheduled or clinic appointments and so forth are also represented. For example, just in terms of the impact of lockdowns, and we can get further into that with analysis, but an example, there were March 42,000 scheduled appointments, and of those, only 82 were impacted by a lockdown. So not to say that we excuse any appointment, but to share at least that impact for those scheduled appearances is relatively low. And we're working with, as the chief said, on programming and other services and figuring out how to do that. Part of the switch to moving away from full facility lockdowns to more targeted lockdowns as necessary is part of that effort, so that the rest of the services in a facility are not impacted.
Has that switch happened?
or is it being rolled out?
Yes, we've already started rolling that out.
Just a comment. Appreciate the changes and your concerns and also Jeff's response to the report. The Board of Correction staff spent a lot of time preparing this, and we hope it's useful to you. And we understand that you could do that, but you can't do it because it's not automated, and you're sending the data out. But it's very important, I think, to look at particularly the variation in the jails and variations by month and variations by warden. Correct. And variations by housing capacity. We're concerned, of course, about two fundamental things: that to the maximum extent possible, that the minimum standards are not violated in terms of people's access to things. And two, that there not be collective punishment. And certainly your discussion, comment about localizing the lockdown whenever possible goes towards that, and I appreciate that.
Okay.
Thanks very much. That's right. Martha, you want to talk about visitation? Yeah.
Visits is the next topic on the agenda. The board's minimum standards emphasize the importance of visits for people in custody in maintaining family and other support systems, maintaining connections with those family and support systems. These connections lead to improved outcomes both during confinement and upon reentry. Visiting is also a huge part of DOC's job and its function, with over 253,000 visitors traveling to New York City jails in the past year. For the past 2 years, the board has published a monthly report on visits, restrictions on jail visiting, restrictions that are used for safety and security purposes, and the appeals that the board receives in this area. This week, we also published a one-year report, a review of all of those monthly reports. In line with this ongoing monitoring, the board reviewed the department's new visit directive and analyzed over a year's worth of visit restriction data, and we sent these to the department in 2017, December 2017. They're also on our website. And during the 15-month period that we focused on, the department issued an average of 40 new restrictions per month to people in custody and 37 new restrictions per month to visitors. DOC issued an average of 319 one-day denials to visitors each month and had an additional 206 one-day cancellations for visitors each month. Over the past year, an average of 275 people in custody were restricted to non-contact visits. That's about 3% of the DOC population, and these restrictions, as we may have discussed in the past, are tools for DOC to handle safety and security risks posed by visits, by contact visits in particular. If you review our December 2017 analysis, you will also see that the board issued responses to 250 restriction appeals during this period. We granted the appeal in 44% of the appeal cases. We granted appeals primarily in cases where DOC failed to adequately document the alleged incident or failed to follow its own protocol for restricting people, such as failing to follow its own penalty grid. The board's analysis also commended the department's progress in implementing a review process for long-term restrictions on non-contact visits. In November 2016, when DOC first began submitting these 6-month reviews to the board, only 36% of eligible people had received a 6-month review of their non-contact status. In June 2017, this percentage had increased to 88%. More work, however, we believe is needed to ensure that these reviews are meaningful. So, for instance, of the 150 reviews conducted during this time, 40 resulted in the continued non-contact restriction for the person in custody, even though the subject had not had any infractions in the prior 6 months. So that is the sum and substance of the 6-month reviews. It goes through, what behavior, what infractions took place in the 6 months, and 40 of those people had nothing on those reviews, but they were still continued in their non-contact restrictions. The restrictions are subject to the 6-month review precisely because they should continue only when contact visits pose an ongoing security risk. Our recommendations based on the data review and on a review of the new directive are all available on the website. Our review of the directive really focused on trying to increase the directive's consistency with the visiting minimum standard and also trying to improve the reasonableness and clarity of the directive's provisions, especially with respect to contraband in the visit process. So I will turn it over to the department to comment on our analyses and then also on upcoming and current initiatives related to visiting.
Good morning. I'd like to start off with thanking the board for this opportunity to talk about visits at the department, and I'd also like to take this particular opportunity to announce the launch of a new initiative that the department is undertaking as of next Wednesday, April 25th, wherein we will be offering a free visitor shuttle to Rikers Island that will go from 2 locations, one in Harlem and the other in Brooklyn. And for the duration of the visit hours, pardon? I can get you the exact location, but it's downtown Brooklyn, yes. Yeah. And then the other location in Harlem is off of 125th and Lexington. So from these 2 locations, there will be a free, yes, I agree, thank you. So the free visitor shuttle will go from these 2 locations to Rikers Island directly to the Perry Center for the duration of the visit hours 5 days a week, Wednesday through Sunday. I encourage everyone to look at the DOC website where there will be additional information such as the exact bus locations as well as the full bus schedule and other information about the visit process at DOC. Thanks to, in large part, the work of the Visit Working Group, Stanley Richards, as well as other members from the Visit Working Group, including a number of advocates and DOC staff, we've undertaken a number of initiatives at the department to improve visits. We renovated central visits. We issued the first visitor handbook in a number of years. We improved signage throughout the process. We separated the bail area from the visit area to make the visit process run a little more smoothly. We hired visit greeters at central visits to greet visitors upon arrival to central visits. We expedited the process for visits at central visits for families with small children during certain days and certain hours, and we improved signage throughout both central visits and the facilities themselves. We also undertook a number of initiatives specifically for women at Rosie's to help improve both the quantity and quality of visits that take place there. To this end, we've done things like changes to the visit floor at Rosie's, hired staff directly for the purpose of improving the quality of the visits between women and their children, and we're currently also looking for programming that will further kind of bridge that process between visits for women with children and other family members. We have looked at the board's recommendations for the visit directive, and we've undertaken a number of revisions to the visit directive in line with the board's recommendations, and we continue to look at other recommendations that the board has made in terms of the directive itself. Some of those changes include including language from the minimum standards within the directive, as well as providing clarifying language as to what constitutes a basis for non-contact visit, and simplifying that process so that that process is more objective, and improving our documentation and tracking records as well for that process.
Any comments or questions? Thanks very much. Sounds very promising.
And I would encourage people so the information for the shuttle buses it's on the website.
Yes.
And I think it's important to say it's not going to be perfect, but we don't want perfect to get in the way of good. This will be a way of families and people getting access to their loved ones at no cost. So encourage people who might be visiting to go and take advantage of the shuttle. Thank you.
Yeah, I would just like to say also, 27 years in the department, and then actually working with that unit visits, that's great stuff. I mean, we were never able to do that and get the resources. Good job, Commissioner. To really focus on, helping out that visit area, and to hear that's actually very exciting. Thank you.
Yeah, I just wanted to say one thing too. This is really terrific news, the idea of this shuttle. I hope you all are going to do a press release and make sure this gets in the newspaper, like the news and the post, so that people are aware, because I think a lot of visitors may not necessarily go.
You're absolutely right.
We want to make sure this information is really publicized.
You can get TV to take the ride with you a couple of times. Like, if that is a really
great
good
idea,
story.
Mike.
Yes, and as Stanley mentioned, the first few days might be a little rough as we try to figure out what the usage is, what the times are, high volumes, low volumes, things like that. But this is going to be a phased approach. So we'll start off with a couple buses on the road, and we will increase the buses with the goal to be that buses will take off from these 2 locations every 20 to 30 minutes.
Is it a Department of Corrections bus, or is it like a city bus?
It's a DOC bus. It will be operated by DOC, but it is a city-funded bus, yes.
Okay, thanks.
Thanks.
Very good. Excellent. Thank you. So the next topic, the last topic before the public comment, has to do with young adult ESH. Since July 2016, the board has granted the Department of Variance to house young adults in ESH. The board last granted this variance at its November 2017 public meeting and will again consider this variance at the May meeting. We will have a consideration of the variance and a vote upon it at the May meeting. And I think Judge Hamill, you wanted to make a statement.
Yeah, I did, and I also have a couple of questions. The last variance in November 2017, the board granted the variance for 6 months for young adult enhanced supervision on a number of conditions, including the condition that restraint shall not be used except to control persons who present an immediate risk of self-injury or injury to others, where it's the least restrictive form to be used, and it's only to be used as long as necessary and not for any predetermined time. So I have a question for the department. What is the Department of Correction doing to reduce its reliance on restraint desks 7 hours a day for 30 days, which clearly by its own language is not least restrictive, is not for only as long as necessary, and is for a predetermined time for all those that are placed in level 1?
Good morning. Timothy Farrell, Senior Deputy Commissioner. Since our last, since the January hearing, our department has refined the review process with the multidisciplinary team. We have a goal to promote pro-social behavior with the population in ESH. The focus is building the self-awareness to improve their behavior, to commingle with general population inmates without engaging in violence. We have a team that consists of both programming staff, operational staff, social services counselors. Those hearings are conducted in a neutral area outside of the housing units. To date, we've conducted 327 reviews. Most of them have had the inmate participate and actively engage with the committee. During those hearings or reviews, there's dialogue between both the inmate and the team concerning how their programming is proceeding, how their behavior is, compliance, rules, regulations, feedback from both the officers and the supervisors, the deputy warden in charge of the unit, as well as with the counselors, to come to objective decisions on how to manage the inmate in the ESH program, whether to advance them, whether to retain them, or whether to regress them. To date, we've had 190, of those 327, 193 have been recommended for advancement from one phase to the other. We've had 25 advance back into general population from the level 3, and those are general population. Those aren't discharges from custody. Those are actual. That is part of the 193, yes. In the young adult, non-blended ESH, we've conducted 13 reviews. Of those, we've recommended 5 of the 13 were recommended to proceed to level 2 ESH programming. But you have to understand that we're dealing with a population that gets into ESH for very violent behaviors. And we try and manage this population in such a way that we can actively engage in productive programming to thwart continued violence behavior. And to do that, we need to do that in congregate settings. We find that's the most effective manner to conduct these programs, to have these groups, to interact, and to gauge whether or not they're going to be able to function in a congregate general population setting. The level 1 ESH, we use the programming desks. We use the programming desks for a couple reasons. First of all, to get into that particular level involves some pretty serious violence. Usually the disfigurement of other inmates, the serious injuries to staff. And those individuals are usually not first-time one-and-doners. Those are persistent, violent inmates. So in order to ensure the safety of everybody involved, the program providers, some of which are volunteers, the staff working the unit, and the other inmates in the unit, we need to ensure that everyone is at a level where they can focus on the programming and not necessarily about what's going to happen next, as far as is something violent going to happen. And we use these programming desks to help facilitate those activities and get a better gauge of how the person is contributing to their own improvement to advance.
Let me just stop you there to ask
Sure.
a couple of questions. I did see that the department has submitted a new variance request for the young adult enhanced supervision, which would be voted on in May, and I really do appreciate the department submitting it so far in advance. Unless I misread it, I don't recall there being any specifics about programming desks in the use of restraint desks. So let me understand. The board has directed through its minimum standards that in young adult enhanced supervision, in all enhanced supervision, the incarcerated person shall have 7 hours of lockout. And that was after very comprehensive, protracted rulemaking at which we came to that conclusion. The board had exempted young adults from being placed not only in punitive SEG, but also in young adult enhanced supervision, and that was on the consent of your commissioner at the time, Commissioner Pond, and Mayor de Blasio and City Hall, because it was all widely known that these highly restrictive measures were harmful to the unique needs of young people. But we granted you a variance on the condition that you were continuing to try to obtain the resources and staffing to try to eliminate the use of young adult enhanced supervision. And then lo and behold, we learned one day that you were locking down the young people. When they were out, they had to be restrained to desks. And at that time, they weren't being called program desks. It's whenever you want to be out of your cell, you have to be restrained. And I've been there many times where they're out of their cells, they're restrained, and there's no programming going on. So is this a change then? Is it that you're only using the desk restraints when there's active programming going on? Or is it that the young people cannot come out of their cells unless there is programming going on, and that's for whatever period of time?
If they're in the level 1 phase,
yes,
their out of cell time is conducted in those programming desks.
But you had said that you needed these desks and the restraints to conduct programming.
Yes.
So my question is, when the young people are exercising their right to be out of cell for 7 hours pursuant to our standards, are they restrained in what you're calling a programming desk even when there is no programming going on?
With the exception of outdoor recreation, showers, yes.
Okay. Now, in your the variance, as well as a letter that was sent to the board by the commissioner explaining some revised procedures, and I do congratulate you and commend you on moving the review from 45 days to 30 days. There is a mention about a check-in in 10 days, and I believe it's called a check-in for to see what type of behavioral progress is being made. Can you further describe what the 10-day check-in is and how it operates?
Good morning, everyone. Good morning. My name is Deputy Warden Jean Renee. I'm in charge of ESH, Enhanced Supervision Housing Areas. The overall safety, security, and operations of the unit, I'm totally responsible for. The check-ins we do. As they come in, we sit there, we give them an orientation process, we let them know what's expected of them as they go through the different phases, behavior requirements, program requirements, things of that nature. Like I said, I'm the dedicated deputy warden for that area. I have 15 dedicated supervisors. Our efforts on a daily basis is sit there and try to sit there and bring whatever type of violence that we can down. We address any type of concerns, any type of safety issues, as well as train and develop our staff as I'm walking through the units. The time period between the locking periods, as we transitioning from one tier to the other, We also utilizing that time to sit there and speak with the inmates, with the staff, I should say, to more or less whatever we needed to address or make any type of adjustment, we're doing so that way when we enter into the next phase as far as the next tier, we're able to sit there and do so in a better fashion. Again, like I said, we are doing the 10-day check-ins. We are speaking with the inmate population. The new multidisciplinary team, the review process, they are fully engaged in it. I'm highly active in it, actively involved in the whole process. To give you a quick example, I had one inmate the other day as he was coming down to his review process, he just straight smiled at me. I said, "Why are you smiling at me?" Because I know I'm going to sit there and move to the next level. This was a conversation that I had personally with him. This is what you need to do. And he did it. He did it in small increments. And then obviously he was successful. That was a success story. And moving one inmate to another.
Why this 10-day check-in that you talk about, and certainly that's a new step forward
Of course,
in this unit. Is there a reason that that can't be a review? Because would you agree with me that at least every expert I have spoken to throughout this country tells me, and the department has failed to present an expert that says to the contrary, that using a predetermined use of desk restraints 7 hours a day for what had been 45, now 30, even 15 they would say, is degrading and is counterproductive for the young people and is much more likely to result in increased violence because of the anger when being restrained for 7 hours.
You have to understand, these individuals work their way into this status based on their behavior, based on their violent behavior. In order to get the programming and get them engaged, we need to do it in an environment that we can maintain and ensure a safe and secure environment. We've increased the reviews. We have my deputy commissioner in charge of programming is at every review that's conducted, him and his team. He personally takes a very vested interest in it. He would be here today if he wasn't on vacation. So you have to understand the staff, the improvements we've made. Everyone is bought into this. From where we were to where we're going, we've got programming that's coming into place that's going to just, with tablet programs, we're increasing the tablet programs. We're engaging with outside providers. We've got the programming coordinators are actively engaged. But you have to understand, there has been a demonstrated past pattern of violence. And if we need to be sure that they are going to be able to function in a more congregate environment, we have to take the time and conduct a very detailed and objective assessment. 10 days is really not long enough to make that assessment based on what their past has demonstrated. And in order to ensure the safety of everybody going forward, we have to make those decisions and we have to make those objective evaluations.
Have you had an opportunity to review the Board of Corrections Young Adult Enhanced Supervision assessment that was conducted by some of our staff, including Emily Turner? Did you have an opportunity to review some of those significant findings and deficiencies in the Young Adult Enhanced Supervision and to try to address those as you're trying to improve the program, try to improve the enhanced supervision?
I personally have not.
And do you recall that you were at many, I just want to speak with him for a moment. Do you recall the meetings that we had? I believe you were at most of those with Commissioner Pont, where when we discussed using enhanced supervision for young adults, it was for a very limited period while you all continued to pilot Secure and ensure that Secure was going to be successful. And then what the plan was to create more secure units because Commissioner Pont, the team then was very mindful that this kind of restriction, 7 hours a day, and that didn't even include restraints, was going to be harmful to the young people. Is it true that the Secure is considered a successful project in terms of a housing unit for young people?
For how it's managed now, Secure has been and has shown success.
So is there a reason that cannot be expanded and the programming continued without literally physical restraints on the young people for 7 hours a day?
What we have found, ESH was newly created. We created it.
Correct.
And as we move forward, we evaluate it. And based on situations and security concerns, we had to evolve within the ESH program. And the level 1 and the programming desks were part of that, based on incidents, violence, and a need to ensure the security of the facility and the inmates and staff. We needed to evolve, and this is where we are. And right now, we are continuing to do that. We are continuing to engage. We're continuing to expand. We've already improved on how we're reviewing the progression through the programming phases. And I think we're making progress.
Now, are you just aware, just my last question before I turn it over to my colleagues, are you aware that certainly because we are in restrictive housing rulemaking, I'm not just making this up, we've been speaking to experts all over the country. We can't find anyone that knows of anything like this that would even recommend it. In fact, commissioners that are very well thought of around the country say that if programming desks are to be used, they should be used for a very short period of time, and that it's counterproductive and harmful. So are you, as you seek to evolve, are you consulting experts around the country? And I know I've offered one expert in particular in Washington, D.C., the Center of Children's Law and Policy, and he's not been contacted by you all, so that he could give you some further guidance on how you might try to mitigate some of the harm being caused.
Well, I'd like to just jump in before you start. I toured ESH, and Deborah Renee was there, and I gotta say, the operation
Excuse me,
running.
could you not interrupt me? I asked a question. Could you just answer my question, then you can say whatever it is that you'd like.
No problem. But I will.
So there's
Yes,
two
of
things
course.
that I'd like to address, Judge. Thank you so much for your critical feedback. One is, as it relates to the report that was done by your team, it was an excellent report, and we did take a very good look at the deficiencies and the recommendations made. And as the department's SDC Farrell mentioned, it is clear that we took into consideration many of the recommendations made. As a result, you have heard that the time frame in which reviews have been done have been lowered and reduced to 30 days. In addition to that, the extensive programming that's occurring, we've also included participation by all young adults and adults inside of the ESH as a part of the review process. They have an opportunity to provide feedback, and those are all evidence-based recommendations that were also made by your team that have been taken into consideration. The thing that you mentioned, and I wanted to also mention to you, is that you said nowhere in the country are they utilizing programming desks.
For 7 hours a day for 30 days.
I heard you. But nowhere in the country have they eliminated punitive seg for 18 to 21-year-olds. So right now, we are in a place where we're also learning, and we have reached out to many different experts across the country that have used programming desks. We've actually gone to Washington State. As a matter of fact, Chief Perino had gone to Washington State at the time at which he was working with the department to look at how programming desks were used. So I just want to make some clarifications and ensure you that the department is committed and continuously looking at evidence-based practices and collaborating with the Board of Correction to improve this process as we move forward.
Let me just ask you, because I didn't get to ask you this, what, if anything, are you doing or recommending be done to try to curtail the use of restraints from 7 hours a day for 30 days?
I've been in charge of adolescent and young adult programming. So there's a number of different things that are being done, but as you know, security is key and critical to the entire operation across facilities. So it's not just within ESH. So the programming reforms that I've implemented and my team have implemented have done great, have resulted in wonderful and positive outcomes for young people. Just one of the things, I know that you met with one of our young people last week.
He actually would like to remain where he is because he's doing well in his pursuit of educational services. So, for example, we have one young man who just took his PRT and his task test. So we have, this week, it was the 16th and the 17th. So there are a number of different reforms that have been conducted throughout the department during this time. And as we have demonstrated, we're committed and dedicated to improving the process as we move forward.
Thank you.
Good?
Sure. Yes.
Okay, I'd just like to add, I did go to ESH, and the operation, I thought would be a disarray. It wasn't. It was run well. It seemed like every individual coming out knew the depth that was there, spoke to them personally, felt very calm coming out. I spoke to the teachers. The teacher says, I love these kids, they like to learn, but I know my kids. If you do not put them to the desk, they will hurt each other, and they will kill each other, and this is a great opportunity to actually learn. So hearing that, it made me feel like we're doing like progress here. All over the nation, these kids would be locked in a cell 23 hours a day. All over the nation. But us, we're getting them out to learn and be out of that small confined area. Personally, I think before anything put in segregation, we should have built a facility that could separate them just by a structure and keep them isolated from each other, but yet not being confined to one room, have a shower, have a TV, and actually to keep people safe. If people aren't safe, nothing else matters. I keep on saying this. So these individuals who have stabbed and slashed people while in our custody, if we allow them to stab and slash other people, which could be my children or your children, that's not a good thing. People are not going to ESH level 1 because they cursed out an officer, or they had words, or they had a fight with another individual. They're going to ESH level 1 because they stabbed and slashed people while in our custody. The department has a responsibility to think of things outside the box. That's why I'm saying with the operation that they're doing, and I've seen it with my own 2 eyes, my issue is you have new officers doing it, but under the supervision of Dep Renee, it seems like they knew what they were doing. 2 or 3 people escorting people out. No one looked like they were learning, and the teachers were saying it was good. So when I sit here and listen, you know, and we're nitpicking stuff where individuals are actually out and learning and developing and maybe changing their life around, I would much rather see that now, and I know it needs work. It definitely needs work. But I'd much rather see that than them locked in a cell 23 hours a day. Because I've seen them locked in a cell 23 hours a day, flooding out, starting fires, screaming, yelling. That was horrible. Okay, the department, the city's going in the right direction. I would like to see it get better. But right now, you know, you need an individual tool to do what you got to do.
So, I have 3 questions. I don't know who best to answer them. One is the process that you described. That's for all people in the ESH, young adults and adults, the 30 days and the review and the participation. How many of the people who were recommended to progress actually progressed? In other words, were there people who the recommendation was to progress out of level 1 who didn't get out of level 1?
We had 69 of the 327 were recommended to progress from level 1 to level 2.
All of those did.
Yes.
If the hearing takes place and there's a recommendation, and then they all go
within a day or two.
Within a day or two. Okay. And my last question is, and are there? I'm sure there are. How many people, in adults and young adults, who are in ESH level 1? Is the 30-day review pro forma? In that you know these people, you know their history, you know what they did last week, you know what they did 6 months ago or a year ago, and you are not going to, and you think it would be unsafe for the institution for them ever to not be in level 1. So
we don't use.
So I mean, the way I see it, there are people who come in there for reasons. I mean, according to our data, 20% of the people come in for reasons other than the reasons they're supposed to, but maybe that's changed. I don't know. you know, but people come in and then some people get out, although most people don't get out. We're going to see the changes when we look at the new data. But is there a population, and how large is it, of people who who you believe cannot change their lives within the next couple of years?
So I just want to speak to the placements. I personally, myself, sign off on all placements into ESH. And I look at a collaborative of different things, where they've previously been housed, the incidents, Gen Tech, and all of the reviews. So there are inmates in which I do not put in that I feel that could be best handled in second chance or true. And if I think that they could be handled in those situations, then they go to those placements and they're not placed in ESH because it is our most restrictive housing area in lieu of removing punitive segregation. So there's a lot of time that's taken to do that, to make sure that we're only putting in the kids that truly belong in that setting. So when they do these reviews, it's really important, and we work with some of the kids. We're working with parents to actually help control their behavior. There's a lot of work that's going into it, and we're not taking it for granted. Absolutely. So I'm just saying that we are doing everything that we can. I don't want to lock up not one kid, but I have to make sure that every kid could be safe.
And just to illustrate some numbers, out of the entire agency, the ESH program is 126 inmates assigned to it. 45 are currently in the level 1. So ultimately it's, excuse me?
That's the adults or the adults?
That's everybody. There's 21 young adults, 19 to 21 in all 3 level ESH programs.
And how many are in level 1?
11. So it's a very small percentage based on the overall population, and that's what we're dealing with. We're trying to get to that small population and have that small population not infect the larger population that doesn't want to engage in this type of behavior. So that's where we are.
Right. And are you finished, Bobby?
Yeah, I guess we'll be looking at it. I mean, if you want to talk, you know what the length of stay of those 11 people are. I'm concerned that for various reasons, the longer people stay on Rikers Island, the more likely they are to get, for all kinds of reasons, you know, that define that population, the more likely they are to end up in ESH1, and that, and then they're going to be there for a long time, which is bad. Do you know what their average length of stay is? Okay, we'll let you know.
We have a long public comment list, so I'm gonna cut this part short.
Couple of things. One, I want to acknowledge the department's commitment and work on young adults. I've been out there over the last couple of weeks, and I spoke to some of the young adults, and I've heard some of the feedback about they are participating in the hearings. One guy said, "I can't wait, I'm moving out." He was. That's the guy I spoke to, and when he's moving out, he's not going to have access to school. That's probably why he wants to stay, because he's in school. But I just want to acknowledge the department. Y'all have done a really good job of trying to move, taking what was in the report about what needs to be corrected and implementing it, really making sure the only people that are going in ESH level 1 are young adults who committed an offense. There's no look back, there's no behavior issue, they've done something. And I think we all agree that the chairs is not what we want, right? But we need to work towards something better, and I see that work happening. And I just want to acknowledge the department and acknowledge your commitment to working with young folks in a way that we don't have to restrain them. And just congratulations, and let's keep working to see what we can do to get better.
Just to let you know, that individual will have access to school.
Oh, you will?
Yes.
He will not. So I'd like to just say I respectfully disagree with my esteemed colleague, Stanley Richards. As I've said, we've spoken to the people in Washington. They were horrified at how it's used here. You clearly have made some progress in terms of more programming, better programming, reduction in the time. But I personally believe that the use of restraint 7 hours a day for 30 days is degrading, humiliating, cruel, and actually unusual in a punishment. I see advocates here with signs calling it torture, asking it to be ended. I believe it's unconstitutional, and I'm just putting you on notice now. May not matter to you. I will not support young adult enhanced supervision, the variance, provided you are continuing to restrain in the same way and wait for 30 days. I'd consider it if you reduce your review period down to 10 days, which is what you said is a check-in for behavioral progression, and some curtailed use of restraints. But as I know I've said this before, for any of us who try to change our behavior, especially for those who have lacked the privilege and the education and the family support that many of our young people have, to expect them to make that sort of dramatic progress before you're going to release them, I think is a little unrealistic. And the determinative factor is whether they're really at imminent risk of hurting other people and themselves at that time, not whether they've made the long-term progress that you're seeking them to make. Because keep in mind, these are pre-trial detainees that have not been convicted necessarily of the charge in which they're waiting. So I'm just putting you on notice. I hope, as I've spoken with our chair about it, that we will have some conversations with everybody, advocates, union officials, the Department of Correction, to see if we can come to some meeting of the mind to change the way that your current restraints are used in the review period. But I do acknowledge that you've certainly made some progress and you've adopted some of the recommendations, not all of them, from Vera and a lot of the national experts.
And I just want to clarify the record too. I am not in support of the restraint desk, but I think it's our obligation to work with the department to come up with an alternative that works for everybody. I don't think it's okay for us to just say that the restraint desks are not okay and just to leave it out there. I think it's all of our obligations to find a solution that works to keep everybody safe. So I think we are making progress, and we need to continue to work together to come up with solutions that we don't end up using restraint desks. But it's all of our obligations to figure out how do we do that.
And with all due deference, I just have to say I've worked really hard on this for years. And since this was imposed, the new condition, in November, we've asked for meetings with the department, we've offered our experts, we've offered all the recommendations. So it's not that we haven't worked with them. Many of us on the rulemaking committee have worked very hard with the department, but I'm just not seeing any progress in the use of restraints, and I don't see it supported.
Public comment period. We have quite a number of people who want to comment, so I think we should move that. As you all know, the comments are limited to 3 minutes per speaker, and in view of the long list, I do intend to enforce that today. In addition to, or instead of your oral testimony, we're happy to receive written comment. You can leave your comments at the welcome table here or email them to us. The public can also use forms on our website to submit comments and complaints about jail conditions. Additionally, we take phone calls, letters, or drop-ins to our office at 1 Center Street. Are we all ready for we're set up? Okay, so the first person is Samantha Cook.
Good morning. My name is Samantha Cook. I'm a student at NYU School of Law, and I'm interning at the Urban Justice Center Mental Health Project. The following is a statement of a currently incarcerated person I interviewed. I'm 38 years old, born and raised in the Bronx. Growing up in my house was rough. It was an abusive situation. Social services took me and my sister from my mom when I was 8 or 9 years old. Group homes, foster homes, I was placed in a lot of them. My mom had told me mental health problems run deep in our family. As I got older, I identified something was wrong, but I didn't know what. I started using drugs to alleviate the pain I was feeling. That's when it got bad. That all started at the ages of 18 and 21. I've been in and out of jail ever since. I'm diagnosed with bipolar disorder. When I was in prison in 2009, I was classified as a level 1 for mental health. I was released in 2013, and I was able to get Office of Mental Health housing. For the next 4 years, I was doing good. I was stable. Unfortunately, in 2017, I was sent to Rikers for a curfew violation of my parole. When I was there, I received mental health treatment. I was given antipsychotic and antidepressant medication and housed in a mental observation unit. Due to my mental illness and Brad H class status, I was supposed to be given a treatment plan when I was released. I needed access to proper services. That didn't happen. Instead, I was released with no active Medicaid and no medication. It took over 10 hours of paperwork to get out of Rikers. They then drove me to the front of the island and put me on a city bus. I went to the Bronx precinct where I'd been arrested to get my keys and clothes so I could go home. I was told that my items were in a property warehouse in Queens. I went all the way to Queens only to find out that they were closed. I couldn't get my keys. I had to sleep on the subway. I felt like a bum all over again. Bipolar disorder alters my mood, and self-medication is a quick fix. I didn't have access to the medication I needed. I couldn't get medical treatment without Medicaid. I couldn't get into my home. Nobody put a gun to my head, but with no medication and no Medicaid, everything quickly spun out of control. I ran to drugs very fast, which led to the crime I was arrested for. I could have hurt myself or hurt someone else. It could have been bad. I'm relieved that didn't happen, but I'm mad that I'm sitting back in jail. If I was given access to the medication I was entitled to, it would have made a big difference. Instead, I was released in May and back in jail by June. I'm concerned that I won't have housing when I get out. I'm fearful that I will have to live in a shelter where it's unsafe and people use drugs. I had been doing well in my house. Now I risk the chance of doing state time. State time doesn't help me. Access to mental health care does. Thank you.
Thank you very much. The next speaker is Sophia Henniger.
Hi, my name is Sophia Henniger. I'm also an NYU law student interning at the Urban Justice Center Mental Health Project. This is a statement of a currently incarcerated person who I interviewed in February of this year at Rikers. I am 49 years old. I was transferred from GRVC to CMC Max Housing at the North Infirmary Command on October 4th, 2017. I have been here for about 4 months. Whenever I am taken to court or outside NIC, I have to wear box cuffs, 2 handcuffs with a square piece inserted between them and a chain connected to the square. The chain is tied around my waist, which pulls my hands tight against my body. This causes the cuffs to hold my wrists at a severe right angle and squeezes my hands, making the cuffs very painful. I had a doctor's note that said I shouldn't be put in box cuffs, but for a few months, the COs ignored the note and put me in them whenever we went to court dates or outside the building. I would have the cuffs on for 4 to 6 hours at a time. They cut off all the circulation in my hands, causing bruising on my wrists and made my fingers swell up. My hands aren't back to normal. I still have numbness, and it's been a few months. I'm supposed to go to physical therapy regularly, but I've only been 3 times. The COs don't take me to my appointments and then mark down that I refuse to go. I really need the physical therapy. I submitted a grievance about this but never heard back. My doctor also said I need an MRI for my hands, but I still haven't gotten one. The COs tell the doctors not to issue the doctor's notes, and I got a new letter from NYC Health and Hospitals saying that I would have to wear the cuffs again whenever I leave the building. I saw my doctor to figure out what's going on. The cuffs are supposed to be waived for me because of the problems I've had. Apparently the administration talked to the doctors, and now only the director can give out notes. I finally got a new doctor's note from the director, and now hopefully they will stop making me wear the box cuffs, but the note only lasts 30 days. There's other problems too. For about a month, I would ask for legal aid services and social services and was never able to talk to anyone. Someone from the Board of Corrections visited, and then it changed. Then the last 2 months, I've been taken to court late, and my case has been adjourned. My court date then has to be rescheduled, and it means I stay in pretrial detention longer. One time this past December, the COs held me in intake and never even took me to court. It feels like they do it on purpose, the COs. It happens to everyone, and too often for it to be a mistake or a coincidence. I wish they would stop. I don't want this to affect the outcome of my case. It's not my fault that I'm late. Thank you.
Thanks very much. The next speaker is Ifosa Akinzua. Is that close? Yeah.
Hi, my name is Ifosa. I'm an NYU law student working with the Urban Justice Center's Mental Health Project. The following is a statement from an elderly individual being held at the North Infirmary Command at Rikers. I, to whom it may concern, would like to address the issues on Rikers Island. It should be closed because of the conditions you are subjecting not only us to, but also our families. It is so hard to get out here that I don't want to put my children through it. And when families do get out here, they don't treat them well and discourage them from coming back. They took me from Brooklyn and housed me here in Queens, away from my community, and they set bail that my family cannot reach. I didn't have a bail set for 17 months, and when I finally did get it, it was $100,000, an amount I would never be able to pay. It was a ransom. The conditions of the living arrangements and conditions of the bathrooms are demeaning. It's not right for a man to be using the toilet with only 2 feet of space from a person using another toilet right in front of him and to his side. Your knees are practically touching. If you reach for toilet paper on your side, you will touch another man's hand. And the showers are so close to each other that the water and the soap from another man gets on you while you're showering. The CO looks directly into the bathroom and at you while you're on the toilet because they are sitting right in front of it. It is demeaning. The bedding situation is crazy. The beds are so close together that I have no personal space or protection against contagious illnesses. For example, I can lie in my bed and touch the person next to me if I simply extend my arm from my bed. And if anyone next to me coughs, it goes directly into my face and I get sick as well. So when one person on the floor gets sick, this causes everyone else to get sick too. The spread of sicknesses is increased by the jail's dysfunctional ventilation. The only attempts at correcting this issue have been to clean the vents to make it look like they work when they don't. The lack of personal space and spread of illness is how the confusion and fights start. Because if someone is doing something next to me that I don't like, what do you think is going to happen since we are so close? I feel like I'm being punished without having been convicted of anything. I'm locked on the floor with 60 other men for 23 to 24 hours straight. When we have to get on the elevator, which is every time we leave our floor, they always tell us to face the wall. It is a form of punishment. I'm an elderly man, and these young guards get kicks out of telling older people to face the wall, to go to the corner. However, it is not all bad. The clinic being so close is a good thing, and there are good officers in the North Infirmary Command. Other buildings try to depress you, but the warden of this building is okay in comparison. These are the things that need addressing or people will start rebelling. This lack of personal space and dignity leads to violence. In the box, at least I get a cell to myself, food delivered to my cell. Why subject us to this? When something happens, they say, why would you do that? But the real question is, why would you put me in that situation? I'm guilty of no crime and being punished by disciplinary action for no reason. This jail situation is like a growing tsunami that starts with little things but ends with big problems. Thank you for your time.
Thank you very much. The next speaker is Jillian Gonzalez.
Good morning. My name is Jillian Gonzalez, and I am a legal intern at the Legal Aid Society's Prisoners' Rights Project. We are pleased by the announcement that the Department of Correction will begin to house transgender individuals consistent with their gender identity, as well as keep the transgender housing unit open as an additional safe housing option. This change has been a long time coming, and it is an important step for the safety of transgender people in custody. We hope that when the new policy is drafted, it will translate into tangible benefits for our clients, and that they will be housed in accordance with who they are and not by their external anatomy. For too long, the board's existing standards regarding housing have been ignored, and for too long, our office has received troubling calls from clients, mostly transgender women who have been housed in male facilities. These testimonies of harassment, threats, and physical and sexual violence affirm the absolute necessity of housing transgender individuals according to where they believe they will be most safe. We are appreciative that their voices may finally be heard. Currently, there is a trans woman housed in the THU that we hope will benefit greatly from this policy change. She is 23 years old, has never been convicted of a crime, and has identified as a woman her whole life. She wants to be housed in a facility that reflects her identity as a woman and believes that Rose M. Singer would be the safer environment for her. She reports that she has experienced pervasive harassment, including when she is taken to court and is transported with men who expose their genitals to her and harass her. In February, she filed a grievance requesting that DOC conduct an individualized assessment that was not based on her external genital anatomy to determine if she should be housed at Rose M. Singer. Her grievance was denied, and she has repeatedly tried to appeal. She has now been told that her appeal will not go through. We do not understand this resolution, and as we said at the last BOC meeting, the department's failure to substantively respond to her grievance makes a mockery of the grievance system. We asked the department to conduct an individualized assessment of whether she may be safely housed at Rose M. Singer in light of her safety concerns and the harassment she has experienced. While we understand that the HRC has given DOC 6 months to develop its directives under the new gender-affirming policy, the principles animating that policy are already reflected in the existing board standards, which require housing based on an assessment of where a person can be safely housed and not based solely on her anatomy. If this assessment is not conducted by the board's next meeting, we ask that you issue a notice of violation to the department. We urge the board and department to ensure that the gender-affirming policies announced are implemented with fidelity and care. Thank you.
Thank you very much. The next speaker is Dory Lewis.
Morning. I'm Dory Lewis from the Prisoners' Rights Project of Legal Aid. We submitted a letter earlier this week detailing the department's failure to comply with your PREA standards, focusing on the abysmal state of investigations. As Ms. King detailed earlier, the numbers of allegations are staggering and increasing exponentially. Your standards requiring prompt investigations are being ignored. With 90% of the allegations from 2016 and 97% from 2017 still pending. Your standards requiring objective investigations are being violated. They're clearly biased, with less than 1% of the allegations or only 4 cases from the last 2 years being substantiated. I don't want to deprecate the department's efforts and their response today, but streamlining closing reports is not the solution. It is not just a matter of paperwork. The Nunez Monitor in the federal litigation has looked at sexual abuse investigations regarding adolescents. In his fourth report, he concluded that these inquiries, and I quote, failed to meet professional standards, close quote. In his 5th report issued just this week, he continued to find the exact same problems. He found, quote, the lack of timely closure severely compromises the integrity of the department's response to allegations of sexual assault. Not only does timeliness continue to be problematic, the investigatory process continues to evidence significant structural problems, such as the failure to interview key witnesses, long delays to witness interviews, and apparent failure to ask effective follow-up questions or collect relevant evidence, close quote. I appreciate that the board will work with the department to develop a more effective corrective action plan. But I think that in doing so, stakeholders can make an important contribution, and you should speak to stakeholders. But I also think, as we said in our letter, that it's important for the board to hold a public hearing on the failure to comply with its standards concerning investigations, asking the relevant players, including the Department of Investigation and DOI, and the Bronx District Attorney's Office if they play a role, and the police if they play a role, to come in and explain their various functions, how they interact, what impact, if any, they have on how these investigations are conducted, and speak publicly about how they meaningfully are going to finally comply with your standards. Thank you.
Thanks very much. The next speaker is Katie Beth White.
Good morning. I represent the Legal Aid Society's Exploitation Intervention Project. Our project serves clients charged with offenses related to the sex trade, including those who have been trafficked. We hold monthly Know Your Rights trainings at THU and advise detainees about vacating previous convictions if sustained as a result of having been trafficked. Oversight and regular convening must continue, as understanding how THU functions will shed light on causes of jail sexual violence and what may reduce it. We support the mayor's recent announcement and BOC's recommendations. As Member Cohen said, this is more than a time-sensitive issue, and I would suggest referring to the studies of LA County's K6G vulnerable person unit for guidance on that. Placement decisions must be the result of proactive screening, not in response to incident, with DOC affirmatively informing all detainees about THU at intake. We hear that detainees still spend weeks in IRC awaiting placement. This should not be the case. To await transfer or to be ignorant to THU's existence needlessly consigns vulnerable people to the worst forms of suffering and abuse. There absolutely must be oversight to DOC staffing, training, and investigation, preferably in design with advocates and THU detainees to all jail staff. If DOC is to implement this in phases, as was suggested, on our many THU visits, we heard of staff, some who even identify as trans or GNC, who wish to retain steady placement in THU and with whom detainees do feel safe. Lack of programming and reentry education in the unit not only serves to deaden an individual's desire to be productive, but it can also foster hostile group environments. Programming builds skills for successful reentry and is often regarded as a favorable factor throughout the life of a criminal case. Due to their identity, many THU clients do not have the support or access that GP prisoners have upon release. So we would also recommend that a study of trans-identified prisoners who recidivate be conducted to clarify the jail's responsibility to individuals' success upon release. It should also be said that however clients might prefer THU to GP, the vast majority would rather be back in the free world. Given the realities of incarceration, relative safety may be the best that we can hope for. However, it is well within BOP's ability to oversee DOC's implementation of these recommendations, and we urge you to do so. Thank you.
Next speaker is Simone Spierig.
Good morning, my name is Simone Spierig. For the last year, I've been a social work intern at Brooklyn Defender Services. In addition to my responsibilities for meeting clients in our city jails, my work at BDS includes tracking the impact of lockdown on clients' needs and their access to legal representation. I'd like to thank the board for their attention in reporting on the department's use of lockdowns and lock-ins. We appreciate your attention to this matter and look forward to working with the board to ensure safety of clients and staff while simultaneously providing valuable programming and services that are essential to people incarcerated in our city jails. Today, I would like to share with you the experiences of our clients and staff during lockdowns and lock-ins. Mr. M reported to our office that his housing unit at AMKC was locked in for 24 hours per day, not for punitive reasons, but for security purposes. During the lock-in, his unit did not have access to outdoor recreation, showers, telephones, the law library, or religious services. Mr. M was denied medical care and forced to eat all of his meals in his cell. Other clients report similar experiences, including barriers to accessing medical and mental health care, attending GED programs, and using other basic needs. Some clients have even reported being denied toilet tissue at times during lockdowns. One of the troubling impacts of lockdowns that our office regularly encounters is counsel visits that are routinely denied and severely delayed as a result of lockdowns. Due to the lockdowns, our attorneys and staff are not able to meet with our clients to discuss their cases and weigh their options. These are crucial conversations that significantly impact our clients, both in their criminal cases and beyond. Lockdowns and the denial of counsel visits are a serious contributing factor to prolonged incarceration of our clients. Last week alone, one BDS attorney waited well over 2 hours to visit a client during the lockdown before ultimately returning to the office without having had an important conversation with the client. Because the client was not able to speak with his attorney before the upcoming court appearance, his case had to be adjourned an additional week and his incarceration was prolonged. Group punishment will not make our jails safer. Rather, people who are regularly affected by lockdowns and lock-ins frequently become more agitated, less stable, and more likely to struggle with mental health challenges. We urge the board and DOC to find effective avenues to ensure safety while minimizing the negative impacts that people suffer when they are denied access to basic needs and prevented from communicating with their legal counsel. Again, we appreciate the board's attention to this matter, and we look forward to continued conversations that address how to better protect the rights of people in our city jails. Thank you.
Thank you very much. The next speaker is Laura Fettig.
Hi, good morning. My name is Laura, and I'm a member of the Jails Action Coalition and a social work intern at the Urban Justice Center Mental Health Project. I would like to just share a few details from a recent visit to Rikers. First, I'd like to acknowledge the great news that there will be shuttles from downtown Brooklyn and Harlem. I think that's great, and I hope it's really widely advertised. So just to share my experience with visiting, the line from the lockers to the metal detectors took about 40 minutes, and that was after waiting for the bus, getting on the bus, and being sniffed by dogs. When I got through the metal detectors, the line to check in was at least 20 people long, and it wasn't moving due to a technical issue, yet there were other open check-in kiosks, and after at least 20 minutes, visitors were moved to check in at other lines, but it took a visitor asking a correction officer if she could check in another line for anyone to help with that issue. When I finally reached the check-in kiosk, I was not told that fingerprinting was optional. I also noticed that the printed out visitors guides, which the department's visit working group has worked very hard to update, were sitting in a stack on the desk and were not visible to visitors, nor were they being handed out at any point. I witnessed one person wait at least an hour and a half before reaching the check-in, only to find out that her loved one's building was on lockdown and having to leave. The department has worked with the visit working group to create a visit greeter position. There are supposed to be 3 greeters at all times on the visit floor, and when I visited, there were none. I also never saw a sign telling me how to report sexual abuse as a visitor, as was mentioned earlier. My visit included 6 searches. All visitors were subject to a canine search when they arrive, and I went through the metal detector at the central visit house, which includes taking off outer layers and shoes. I set off the metal detector and was pat frisked. I was not given a copy of the consent that I signed. My hands were then checked for drug and explosive residue. When I arrived at the facility, I went through another metal detector search, and when I was called to the visit floor, I, along with all the other visitors, went through yet another pat frisk search before being allowed on the visit floor. So that's 2 pat frisk searches and 6 total searches. When speaking with visitors, one of the most pressing issues we've heard over and over is the long wait times, and the minimum standards state that the department shall make every effort to minimize the waiting time prior to a visit, and my experience indicates that the department is not making this effort to the best of their ability. Given what we know are the benefits of visiting for families, incarcerated people, and jail safety, I urge the department to listen to visitors and make visiting as accessible as possible. I also just want to say the improvements to visit areas for women at Rosie's to visit with their children are really important and great progress, but I'd like to reiterate that the vast majority of children who visit Rikers visit the men's facilities, and the same resources should be available in all facilities to improve visits for children and their incarcerated parents. Visit tables should be replaced to facilitate contact between children and their parents instead of hindering it. Thank you, that's all I have.
Thank you. Jennifer Parrish.
Good morning. My name's Jennifer Parrish. I work at the Urban Justice Center Mental Health Project, and I'm a member of the Jails Action Coalition. First, I just want to commend this board on its work to increase transparency and accountability by all the data collection and reporting that you're doing on visits, visit restrictions, on lockdowns, on ESH, sexual assault. That's so important to making the changes that need to be made at Rikers Island. I'm disappointed, however, in the board's response to the department's failure to comply with the restrictions on the use of restraint desk and ESH. You adopted those in November when you granted the variance, and the board was unanimous in its opposition to shackling young adults in these restraint desks for the entirety of the 7 hours out of cell. Yet the department has ignored those limits, and the proposed variance that you'll be voting on in May suggests that they don't plan to comply. So I ask that you reject their variance and that you let them know in advance so that they can be planning something else. As Judge Hannibal mentioned before, when this young adult experiment was started in the beginning, there were no restraint desks and it was supposed to be temporary. This has gone on long enough. The Board of Correction was critical to ending solitary confinement, and we need to end the use of restraint desk. If there are 12 people there, surely there's a safe way to manage this population without confining them in this inhumane and degrading way. Thank you.
Thank you. So the next speaker is Grace Price.
Good morning, my name is this on? Yes. I have to lean in. I shouldn't have worn heels today. Good morning, my name is Grace. I'm with the Jails Action Coalition. I'm the only formerly incarcerated person, as you know, and I like to brag about this, that regularly attends these meetings and gives this august board and this body the respect that I feel it deserves. Of course, they call me Grace for a reason. I didn't mean to imply that some people don't respect this board that are formerly incarcerated people. I think most of us are very proud with the representation that you give us. I'm here today also to remind you that we've been discussing this issue of rape and sexual assault on Rikers Island and in our city jails for over 3.5 years, and today we are in a worse place than we were when we started discussing this. The closing rate at 0% since 2017 is shocking. Especially since the leader of this board, Mr. Cephas, in September, specifically asked the head of the investigations department why we had such an abysmal closing rate. Since September, apparently not even one case has been closed. And that's 8 months that absolutely nothing has happened. I just want to point that out because I don't understand, even if the paperwork and the administrative issue is really the juggernaut, I just don't understand why anyone would ignore Mr. Cephas's request to bump up the closing rate. It's ridiculous. I really need to speed up because I don't want the guy with the cane to come pull me at the end of the 3 minutes. But I want to say, Ms. Townsend, I welcome you. I have all the respect for the Brooklyn DA's SVU unit. It was the first in the country. Liz Holtzman did a great job establishing that unit many years ago, and anyone that comes from that unit has my utmost respect. My sister in arms, Lauren Hirsch, used to work at that unit, and I will definitely ask her about you, and I will ask her to put in a good word for me with you as well. So very quickly, there are so many parts of the PREA implementation schedule that haven't been implemented. We need an updated, revised schedule. We don't know, as to JJ's question, we still don't have a plan about supervision and monitoring that was due last July. We don't know anything about ongoing medical and mental health care. What's happening when people are being let out of Rikers Island and they've made a complaint? Is there a referral for ongoing services? I know Chris Bromson at the Crime Victims Treatment Center would love to get those referrals. What's happening? Are there MOUs with other agencies? I can't believe my 3 minutes is up. I have so much more to say. I will submit these comments. I actually wrote them down today. But what about the visitor complaints? Like, where are those stats? We don't know anything about the cases closing rates from 2014 and 2015. We've never heard updates on those things. There's so many more questions I have to ask. I'd really like to be included in all these conversations. I promise to show up on time and respect the limits. Thank you so much for listening to me.
Thank you. The next speaker is Herbert Murray. Sorry, no. All right, we'll put him. He can get back into the list whenever he comes back. Next speaker is Jeannie Workman. Next speaker is Lavina Talukader. Maybe I didn't do that right either.
I'm an MSW intern. My name is Lavina Talikter, and I'm with the Osborne Center for Justice Across Generations. I'm here to read statements on behalf of a mother whose son was formerly incarcerated on Rikers and Dr. Goshen. My son was incarcerated on Rikers Island from 2010 to 2016 waiting for trial. During those 6 years of unfair and unconstitutional pre-trial detention, my son lost hope in the justice system and became more depressed each day. The only hope he had left was seeing his mother every weekend for the 1-hour visit. Without trial on the horizon for many years, without his attorney visiting him and discussing his case, without anything to hang on to, the visits were his only hope. It is extremely important for incarcerated people to see their family members and their friends. It is extremely important for them to be able to see them in person, being able to touch, hug, and kiss them. It's the only hope left for them when they are in a cage all day. Even though the visiting process is usually very harsh and time-consuming for visitors, as a mother, I never allowed the harsh conditions to deteriorate the quality of the visit with my son. The moment he saw me, he felt like a human. I could see how he needed my motherly touch to let his anger and frustrations disappear the minute he saw me. After each visit, he felt better and had more positive energy to keep going and to look forward to the next visit. Allowing visits as often as possible in jails and prisons is such an important part of any human being. Not only does it give hope to the incarcerated person, but it keeps incarcerated folks mentally and emotionally stable. It makes their negative emotions go away and gives them something to look forward to. Please don't reduce visits with incarcerated folks. The results could be destructive. Now I'll read comments on behalf of Dr. Goshen. My name is Lori Goshen, and I'm an assistant professor of nursing at Hunter College in the City University of New York. Having worked as a corrections nurse, I deeply understand the importance of facility safety. Restricting visiting is a counterproductive form of discipline and does not promote the short or long-term outcomes we want to see. Positive reinforcement is a more effective mechanism for behavior change than punishment. For this reason, I argue that the potential incentive of additional visits for good behavior is likely to be a more effective approach than taking away visits for negative behavior. Visiting is a key way that incarcerated parents and their children maintain the parent-child relationship. Instead of placing further limits on visiting, which is already incredibly difficult, I urge the board and the department to instead invest in improving the visiting experience for children and families. For example, incarcerated people receiving visits from children should not have to be separated by the plexiglass barrier so that children can already sit on their parents' laps. Each facility should offer toys and games that children and parents can play with together during the visit. The officers interacting with visitors should be trained on child-sensitive ways to implement their security protocols and to understand the critical opportunity they have to make a lifelong positive impact on a child. I encourage the board to maintain minimum standards of visiting, to move towards more, not less visiting, and to improve the quality of the visiting experience to assist people in maintaining the networks that will be critical to them upon release. Thank you.
Thanks very much. So the next speaker is Victoria Phillips.
Good morning. My name is Victoria Phillips. I work at the Urban Justice Center Mental Health Project. I'm the Community's Health and Justice Organizer. I want to keep it quick. I'm going to jump right into it. So I want to touch on investigations. I've testified before this board before on investigations and how I've reported stuff, how my job was threatened while working on records for reporting things, and how investigators actually took 6 to 7 months for each case to get back to me for the first response. Jails Action Coalition, I'm a member of Jails, I don't know if I remember, I'm trying to hurry up. Jails Action Coalition, we actually brought to this board a recent former DOC investigator who herself testified on how the process of investigations is flawed. Look back in the records if you want her story. I want to know how many cases, when they said that they present 12 cases on Wednesday, out of that, all of them being allowed to present those 12 cases, how many cases do they actually present every Wednesday? And I also want the board to find out how many cases that they say are substantiated from rape allegations or sexual assault allegations, how many were officers? And last month, I actually stood before the board and brought up the stats for 2016 and sexual allegations, and I said it was over 800. Today, it was mentioned that 55 of 2016 were ready for closing memos, and that in 2016, 181 allegations was from 17 people. That out of that 181, I went from 800, let's just say 800, I don't know exactly how many it is, that will leave 619 cases. What's going on with those 619 cases? And out of the 55 that are set for closing, how many of those cases is actually from the 17 that the investigator mentioned today? There's so many different questions that need to be addressed. When we speak about ESH, I'm appalled that there are people in the medical field still here that will not stand up and speak about ESH in the shackles and how abusive it is. I worked almost 10 years in the hospital, and I know for a fact that we cannot have someone in restraints without releasing them without it being every 2 hours. So how is it that DOC with no medical expertise at all is allowed to have anybody in restraints for 7 hours? And we both know that DOC does not comply, so they're in restraints for longer than 7 hours. Let's be clear about that. I just want to encourage the board to keep demanding the stats and facts and demand them in a timely fashion. It's extremely important. People's lives depend on it. And I just want to make one more thing. If you look back on the tape last month, I spoke about medical and how important it is, and how as a brain surgery survivor, it's important for incarcerated individuals to be brought to medical, to actually have the officers do their job and not think that they're medical staff and deny people medical. Today, there was a report that somebody was still waiting for an MRI. MRI saved my life. This is something that they don't have access to on a daily basis. And it's not the officer's decision to decide who goes to medical and who does not. Pay attention to that stuff. Stay blessed and do your job.
Allison Holhan.
Hi, I'm Allison Holohan, the Senior Policy Manager for the New York Initiative for Children of Incarcerated Parents within the Osborne Center for Justice Across Generations. The initiative represents over 60 organizations. We strongly affirm that visiting is a right that is beneficial to children and parents and supports the very goal DOC and COBA seek, violence reduction. The Commissioner herself points to the benefits of visiting, quote, "Maintaining personal connections and establishing support systems is critical to the improving an individual's success during and following their time in department custody. The department further encourages these connections for their demonstrated ability to improve violence reduction, reentry outcomes, and community safety," unquote. We share the desire that Rikers be a safe place for staff, visitors, and those incarcerated. Visiting is a part of what makes the place safer. Corrections leaders acknowledge that violence is down on visiting days. Research finds fewer infractions among those who receive visits. Limiting visits will increase violence. From a child's perspective, visiting is a right, not a privilege. Children of Incarcerated Parents' Bill of Rights asserts, "I have the right to speak with, see, and touch my parent." In fact, visiting is a protective factor that mitigates the trauma of being separated from a parent. The department already has the ability to restrict visits to non-contact visits. DOC acknowledges the majority of visitors don't bring in contraband. We recommend that the department try incentivizing positive behavior by approving additional visits to those who follow rules. It is incumbent on all of us to safeguard the needs of thousands of children, but yet these children are invisible to the department. The department reports on the number of visitors, but this does not include visitors under 16. How many children visited? What facilities do they visit? This data must be there since for the department records all humans on the island at all times. This information is critical to improving children's visiting experiences and implementing visiting-related initiatives. Also, there is no distinct pat-frisk procedure for visitors who have children with them. There is no distinct canine search procedure when children are present. The minimum standard allows for contact between children 14 and under and their incarcerated parents and family members. Yet the department installed a 6-inch plexiglass barrier, making it impossible for children to reach the laps of their parents and to hug them. This is not acceptable. We urge the board to work with the department to implement options that allow children to have physical contact, and we can assist in this process. I close with the following requests. How are PAT searches conducted when children are present? We'd like to know, and we'd like for these procedures to be strengthened to minimize trauma to children. Same for the canine search procedures. We'd like to have the department monitor and report on the implementation of the expedited visit times for visitors with children, and to track and report on the number of visitors under age 16. And also to make sure that the minimum standards are complied with and the 6-inch plexiglass is removed. Thank you.
Herbert Murray, is he back?
Yes.
Yep.
Yes, I'm back.
Good.
Good morning. My name is Herbert Murray, and I am from the Just Leadership USA. I am one of the leaders of the campaign to close Rikers Island down, and we need to close it down now. Rikers Island has a long history of violence. It is a culture of violence. When I was there in 1981, I was placed in a cell block where you had approximately 120 residents. You had 3 TVs, pardon me, we had 1 TV, 3 telephones, and 8 showers for 120 individuals. That right there generates violence over and over. I remember that, you know, when I was there, I got there a week, and the individual got hit in the head with a mop wringer, iron mop wringer. And when that individual attempted to hit him a second time, I grabbed him because out of sympathy. Because when I say sympathy, that means that those who are in prison, we mind our business because we don't want no trouble. Because the trouble's there. It will come at you in an instant. You'll blink an eye and you might get stabbed in the head or so. So I grabbed this out of sympathy, this individual, and held him until the correction officer come. And he didn't come, those guys didn't come until about 15 to 20 minutes. And that is because they are behind an iron gate, and when something transpires inside the cell block, they press a button for the riot squad to come. And the riot squad is comprised of different individuals throughout the jails. So they have to come, get together, put on their riot gear, get in formation, and march to the, and by that time, all hell broke loose. There's no security there. That's what you call security, and this is the ongoing basics. You know what I mean? It is so frustrating being in those, and being in Rikers Island, that it just, you know, 120 people on top of one another, we just gonna be frustrated because we're not getting no justice from the criminal justice system. We are in a system of a 19th century laws that is not conducive to nobody. So we need to close it. It's corrupt, it's violent. It can help the officers as well as the residents. But when I was there, I knew 2 correction officers. Yes, they was bringing in contrabands from me. And this is what's going on in there. So we need to close it, and we need to close it now. Thank you.
Jeannie Workman, is she here? No. Mick Kincaid?
Thank you all for waiting so long. I know it's been a long day. I'm Mick Kincaid. I'm from the Sylvia Rivera Law Project. I'm the director of the Prisoner Justice Project. First, I want to thank the board for the THU assessment that was provided. For the past 3 years, I and other advocates have come up here, and we have been highlighting the horrible mismanagement of the transgender housing unit, the unclear application process, the delays, the denials, the continuing misgendering and mistreatment of the women who are in the unit. It's very validating to see the board take this seriously, to research it, and to produce this report that echoes what we already know is happening. It's already been mentioned today, but I want to highlight the need for the incredible reform and overhaul of how the DOC responds to sexual violence, the trainings, and the prevention measures. The PREA investigative report that was announced some months ago highlighted that there are 739 cases still pending from 2016 alone. Those individuals are not in DOC custody anymore. 2 years of their lives have passed, and the message that they received from DOC and from PREA and from the city of New York is that their survival didn't matter. News travels really fast in jails. Those 739 people still waiting for their investigations from 2016 have shared that experience with others, and the response will be a chilling silence. People do not report to PREA if they do not think they're taken seriously. Why would they share a traumatic moment of their lives with the very people who are in control of their lives, knowing that if they were lucky, it will be investigated close to 3 years from now? From 3 years from now, there will no longer be videotape, there won't be medical reports, they won't be able to find the witnesses who may have witnessed what happened to them. It's a complete disgrace. And this is highlighted by what recently happened to my friend. She asked me to read the statement to her. And I will say, when she first gave me the statement, she wanted me to say her name out loud. She now is so terrified she doesn't want her name to be said. I am a trans Latina who has transitioned since age 13. I have been through hell with DOC. First I was at Rose, as I am a woman. Then I was taken to the THU. Then to AMKC, where I was raped 2 times within 1 week. After the first rape, I was returned to the same facility where I was raped. I was placed as far away from the bubble as I could be. I had to argue to be seen by medical. I was raped 2 times, and I will never forget the loneliness, the pain, the destruction. This has changed my life. On Wednesday, she and I sat in her hospital room at Bellevue, and she said to me, no one in PREA has used my right pronoun. No one has seen me as a woman. They took me from Rosie's to the THU to a dorm-style men's facility, and they expect me to trust them with this information and with my life. They think I lie when I say I am a woman, so why would I ever tell them anything? I will also just add that when we complained to PREA about her placement back at this exact same facility where she was first raped, we got no response to the fact that she was actually raped. All we got was a statement of defense as to why she wasn't in the THU. There was no acknowledgement that a woman had just been raped. My friend is right, and she is not alone. For every woman like her, there are so many other women and men and gender nonconforming people who do not know their rights and who do not report what happens to them because they do not feel safe reaching out. And the immense psychological impact of just surviving the sexual violence that they have experienced. The statistics around PREA and my client's experience carry the message that sexual violence isn't taken seriously by the DOC. More than that, for trans women, their identities are not taken seriously. Why do so many women wait an average of 88 days before they even apply to the THU? Why was my friend placed in a dorm-style setting in a men's unit unless DOC wanted to send her the very clear message, you are disposable? But she is not disposable. She matters, she is my community, she is all of our neighbor, and she will tell her story. And in light of all this, I urge the board to issue a notice of violation for the minimum standards around sexual violence.
Thank you. The next speaker is Vidal Guzman.
My name is Vidal Guzman. I am the community organizer for the Closed Rikers campaign. So I really want to talk about how correctional officers use violence to de-escalate violence. We have to have that conversation. How do you use violence to de-escalate violence? We need to have a way that correctional officers need to know the training how to de-escalate violence. As a person that firsthand experience that dealt with violence at 16 years old when I my first time in Rikers Island, I was not welcomed and protected by correctional officers while I was in there. The first time I was actually in there, you had a guy who was 300 pounds, 6'5", while I was 5'4", 120 pounds, 16 years old, strike me because he said I didn't do what he said to do. And as also being there, understanding they also need training to understand how to deal with people who are dealing with mental health. My first week that I was actually in there, I seen 3 guys back to back hang themselves, 16, 17 years old. So as we talk about what is actually going on in there, we should also talk about the trauma before a person even actually land into Rikers. I'm formerly incarcerated. I'm 26. I did 7 years, and I'm also formerly gang related. So I was a high-ranking member of the Bloods. So what did Rikers really create for me? It created more trauma, more deeper tissue of mentally spiritually and physically break down. While I talk about this, you could kind of hear the experience of me bringing back the trauma that correctional officers had did to me. So I'm only one voice, and I live in neighborhoods that are individuals who are black and brown that are coming home. I'm speaking for the individuals that are not here, that are dealing with deeper traumas that correctional officers had actually did. So while I was locked up 16, 17, I came home when I was 18, probation, dealing with the trauma that correctional officers had deepened. At 19, I was again back in Rikers all the way till I was 24. I'm on parole right now as we talking. So when we talk about what the trainings that they need to have, we need to definitely talk about the trauma they're actually creating. And I'm still hearing about the trauma that a lot of the individuals are dealing with, for a lot of people from the neighborhood that are 16, 17 years old. And language. I really want to talk about language. We're not inmates. We're formerly incarcerated. If a person's detained in Rikers, they're detainees. You using inmates in your language or your speech do not make your speech powerful. It makes you unhuman. So while we correct that, we definitely want to correct that. And if you're working in the criminal justice system and you're using an inmate to make your voice or your sentence or whatever you say powerful, that is unhuman. So my name is Vidal Guzman. I am the community organizer for the Closed Rikers campaign, and that's all I have to say. Thank you.
So we have one more name, but it's illegible. There's someone from Osborne who hasn't spoken, who's signed up. I can't read the name. Going once, going twice. Okay. That's all we have. Motion to adjourn. Thank you. We meet back here on May 8th. Thanks very much, everyone.